Also, David and Paul Amos, if you'll mute yourself until you're called on.
Good morning. I'm Judge Tammy Long Hayward. This is the criminal motions calendar for September 18th, 2024. This is Clayton County State Court. We'll begin with the reading of the calendar. If you're represented by an attorney, your attorney is going to speak on your behalf, but I do need to know that you are here. First things first. I need your first and last name on the screen. I don't need a nickname. I don't need your phone designation. I need your first and last name on the screen. So if you don't have your first and last name on the screen then that's going to be an issue. Please go ahead and change that now. You can rename yourself. Click on where you appear, whatever your designation is. Put your cursor on that part of the screen or your finger if it's finger activated, and then you should see a box with 3 white dots in it. Click on that again. A pull down menu will come out and it'll say rename during one of the choices. So go ahead and rename yourself so that I know who is here. It's a lot easier to move people around if I know your first and last names. Thank you. So Robert Bell IV, this is a case has been closed. Nazir Haru Cooper, motion to revoke bond.
Your Honor, the state is ready.
Mr. Holt Dennis.
Good morning, Your Honor. Mr. Cooper's present in the courtroom.
All right. All right, we'll begin in a moment. Let me go ahead and get through the calendar. Suzanne Downing, Jacoby Hudson, this case was closed.
She's there in the courtroom, Your Honor.
All right. No objections. Ms. Downing can be excused. Any objections?
Not
all right. I'm sorry.
Not from the state.
Okay, thank you. Ms. Downing, you're free to go at this time, ma'am. Thank you. This was scheduled prior to you closing your case, okay? Just continue to do whatever your sentence was. Driggers, David Everett Driggers, that case was closed in July, but there's a motion to seal. Has the state had the opportunity to look at the motion?
1 second, Your Honor. You can just hold for my report on that one.
Okay, no problem. So with Driggers, we'll review the motion. If there are some cases that we can seal, some cases we cannot, depending on the type of case. So we'll look at this and make a determination. And if we need to ask you any questions, Mr. Driggers, then we'll go ahead and ask those at the appropriate time. Alicia Graham, that case was closed. That was on a motion to modify bond, but the case has since been closed.
Judge, is it the case just been, because I'm the attorney on that case and we haven't gotten any paperwork, so the case just been dismissed?
On August 21st of 2024, I believe I signed a no pros. Yes, sir.
Okay.
No, Your Honor.
I didn't? Why is
No,
it closed?
the case was accused.
Ah, sorry. I'm looking at the wrong number, the TS number. It's got a TS number. So it's actually got there are two cases. And there's a motion to modify bond conditions, but the reason that we're on the calendar, I guess, is to modify the bond conditions. It says it's closed, but that means the TS number is closed out and it's being accused.
Right. Well, Judge, that's my motion, and Ms. Graham is on the Zoom call. We're just trying to modify the bond conditions from no contact at all to no violent contact. It's my understanding that the alleged victim is okay with this. So I don't think anybody is really against this idea, Judge. They have a child together.
All of them have a child together, Mr. Rigdon. That's
I
where
know
we
it.
see the most violence. So, yeah, that's usually the issue, is that they got a child together. So that does not in and of itself mean this case should be modified, but I will hear it. Just give me a minute to get through the calendar, okay?
Sure.
Thank you,
Your
Ms.
Honor?
Arnold. Yes,
So I should stay on the call to see if it
are
will
you
be
Mr.
sealed?
Driggers?
Yes, ma'am.
All right, hold on. Let me change the name on the screen so I don't lose track of you.
And then I had a question about the CT at the airport.
The CT. Oh,
Since my case was dismissed, does that get dismissed as well?
I only have one case in front of me, sir. You have more than one?
Well, no, that's why I did the PTIT, because of the CT at the airport.
Okay, hold on. When we come back to your case, in conjunction with your attorneys, I'll be able to answer more questions. Okay, because I have that it was dismissed before it ever got to me.
Right. Yeah,
So
I did the PTIT program.
okay, so it should be sealed based on that program, and once that's sealed, then it shuts down everything.
Well, it was restricted, but that's why I was doing a motion to get it sealed.
I got you. Like I said, just give me a chance to look at it.
Yes, ma'am.
So, ladies and gentlemen, I'm not being hard to deal with. My calendar says very few things. It tells me your case number, your name, your attorney, a brief note about what the case status is. Some of them have a note, some of them don't, and the name of the type of motion that you're asking me for. So it doesn't give me anything else. The whole purpose of the motions hearing is that I'll get all of that information once we start talking about your case. So when I call your name, at that point, I'm not really prepared to answer a whole lot of questions.
Yes, ma'am.
All right. So we'll go back to Ms. Graham's case. Ms. Graham has two cases. Alrod Jamar Jackson. That's on a motion to revoke bond. Alrod Jackson.
Judge, Mr. Jackson is present in court, and we intend to enter pleas today. I've discussed that with Ms. Hagler, and I believe we're pretty much on the same page. I just want to make sure that, well, I believe we'll enter a plea. I would just ask her to send me the recommendations. There was a discrepancy with the jail time. I know Ms. Hagler indicated that she was not asking for additional jail time. I just need to make sure I've advised my client as to all the conditions, but he is prepared to enter a plea to both the cases on the calendar.
Okay. Well, can you chat her a specific question about the jail time? If all the other stuff is the same, why does she have to repeat the recommendation?
I mean, that's fair enough, Judge.
Mr. Lynch, brevity is the soul of wit. Somebody much smarter than me said that. If what you're asking for is a specific clarification, chat that to her. She can chat it back. No need to redo everything.
Come on, get up. Y'all got shirts on. Come on.
But can we just hold for that plea?
Okay. Marcus Cleve Jackson. That was the Mr. Fry's case. He was here before and asked for the motion to suppress. He was put on the motions calendar, and now he has some conflict, which he didn't tell me about. So we'll have to figure out what's going on with Mr. Fry. Let's see. Sierra Michelle McKinley, that's a motion for immunity.
Judge, Ms. McKinley is present and we are prepared to go forward.
Okay.
I did-
Dominique, go ahead.
I did have some information I wanted to present to Ms. Hagler about that case.
All right, email it to her. Dominique, Dion Myrie. Dominique Dion Myrie. This is also a motion for immunity. Last call for Dominique Dion Myrie.
The state will ask to deny the motion.
Mr. Taylor?
Yes, Your Honor. On behalf of Mr. Murray, we withdraw the motion for immunity.
All right, motion has been withdrawn. Joshua Antoine Pratt. This case was closed. Brandon Virueta. This case was closed.
He's there in the courtroom, Your Honor.
All right, Mr. Virueta, you're free to go at this time. Your case was closed. Elena Worthy. So there's a series of motions. Kirby Clements.
Your Honor, the defense attorney did request to have this case continued, and I believe that request was granted. So the defense attorney did request the case to be continued.
So that must have been one of the ones that got sent to me during the week.
Yes, that sounds about right, Your Honor.
All right. That concludes the call of the 10 a.m. calendar. Are we ready on the motion to revoke for? Well, let's see. Does the state have any objections to the modification on Graham?
Y'all, let me get with my victim advocate just to confirm.
Okay,
that
so
the victim does not have an issue.
all right, so y'all talk about that, but let's go ahead and get ready on the motion for Cooper. Nazir Rue Cooper, motion to revoke bond. I know you have officers here on for that. So
Your Honor. Your Honor.
yes.
Mr. Beretta, you say his case was closed. He's
Yes.
is there paperwork issue because he stated that his license was suspended and he needed documentation.
He can go to the second floor at the traffic court window and ask for a copy of the sentencing sheet or the dismissal. He just ask it for the resolution of his case. They can print it out for him.
Your Honor,
Yes, ma'am.
he has a motion for limited driving permit.
Oh, I didn't see that. Hold on a second. I just saw the motion to revoke for him.
Brandon Berwetta.
Yeah, Mr. Rueda, hold on a second.
Yeah, it's a motion for a limited driving permit.
I don't know. Is that something I can give him?
Yeah.
I don't think I do anything. There's paperwork in the clerk's office.
Yeah, he should be able to get the paperwork from downstairs so that way he can take it to DDS.
Yeah, Mr. Vuelta, you can get that paperwork, go to the first floor clerk's office, the state court clerk's office on the first floor of this building, and ask for a limited driving permit paperwork, and they should be able to help you with that. I don't generally sign off on those. That is usually between the clerk's office and the Department of Driver Services, because I believe the clerk's office provides the information about what happened, and then the Department of Driver Services determines whether they're going to grant it. So I'm not in that process. So I'll excuse you to go ahead and head down to the first floor. Thank you, Ms. Arnold. I totally missed that. Something's going on with one of the lights in my office, and so I'm sitting here in dim light. Can probably half see what's going on. We'll work with it though. All right, so we ready on Cooper?
Your Honor,
Yes.
in the matter of Mr. Cooper, I've requested from Attorney Hagler a sentence recommendation to see if we could resolve this matter today. Also, the alleged victim in Mr. Cooper's case on the case before the court, two terroristic threats, is in the courtroom, and I would ask that he be able to address possibly the victim advocate or Ms. Hagler, because he's informed me that the basis of these charges are inaccurate, and that may make the bond modification or the bond revocation motion moot.
No, he has a new offense. So why would that make it moot?
Yeah, that's not a bottom. Cooper is a motion to revoke.
Yes, Your Honor. However, I'm just asking if the state has a sentence recommendation to resolve Mr. Cooper's case, and
Okay.
also the victim in Mr. Cooper's case is present in the courtroom and wishes to speak to either yourself, Your Honor, or to the victim advocate to explain his position, which is that the basis for the allegations of terroristic threats are inaccurate, and he's prepared to go under oath and tell that, since this is going to affect Mr. Cooper's
Well, why can't I just hear it during the motion to revoke bond?
Yes, Your Honor, certainly we can have that, but I'd also like to have a sentence recommendation on the charges should Mr. Cooper wish to resolve the entire case today if the state decides to proceed forward.
Well, yes, you should have already received, and Ms. Arnold can confirm, you should have already received the recommendations for the terroristic threats, which wouldn't have changed from the time you received it to today.
I'm just asking, can you tell me what they are?
Yes, okay, I'll repeat it. Yes, so count one is 12 months probation, a fine of $300, 40 hours of community service, anger management, and no violent or harassing contact with the victim. And then count two is going to be 12 months probation, 40 hours of community service, again, to have no violent or harassing contact with the victim and to run consecutive. There are actually two victims in this case.
I have Mr. Derek Cooper as the named victim, the victim, please.
You have what now?
I understand that Mr. Derek Cooper, Mr. Nazir Cooper's father, is one of the alleged victims. I'm asking, she said there was a second victim in the case. I'm asking.
Okay, let me confirm, give me 1 second. Go back to your report. Derek Dwayne Cooper, and then Leon Cooper. I'm showing.
Okay.
So that's the recommendation for both charges.
I'll speak to my client briefly, Your Honor, and then we'll be ready to proceed.
All right.
Thank you.
And Your Honor, while we're waiting for Mr. Attorney Taylor, I did look at Drigger's petition, but the petition is blank. So I'm not sure why he left the petition to seal blank. There's no information entered on the petition.
Mr. Driggers?
Yes, ma'am.
Did you just submit a blank form or what happened?
Well, I was working with Lester Holtz, and Chelsea told me that she could help me to seal my case, and then she backtracked, said that she misspoke. And so I was trying to do it on my own. And I thought maybe you had a copy of where I did the PTIT program and was going to explain.
I get that, but for a motion to seal, I know it's like a form document, but you still have to fill in the information on the form.
Okay, well, when I did it at the clerk's office or whoever submits the form in that department, she just basically took a copy of that I did the PTIT program and said they put me on the calendar.
Okay,
So I thought maybe I could explain myself today. I'm not familiar with the procedures.
I got you, Mr. Driggers. All right, do you have the form, a copy of the form with you?
I'd have to look and see if I do.
Look and see.
Okay, 1 second.
And then, Your Honor, when you're ready, I do have an announcement on the motion to modify conditions.
I'm ready.
I did receive word from my victim advocate, and we have no objection to no violent or harassing contact.
All right, and Mr. Rigdon, that's what you were asking for?
Yes, Judge.
All right, did you submit the order?
I'm honestly, Judge, it's been a while. I don't recall if we submitted an order or not. If we didn't, I'm sure I can get one to you shortly.
All right, if you will submit an order, my staff attorney is Kiera Powell,
Sure.
K-I-E-R-R-A, Powell, P-O-W-E-L-L, and you can email that to her, and then she'll get that to me.
Great, Judge. Thank you. May we be excused?
Yeah, now, Ms. Graham, until you get the order, a copy of the order, you got to wait for your copy of the order, but I sign electronically, so once it gets to me, I'll send it right back to the clerk's office, okay?
Thank you, Your Honor.
A copy to your attorney. But please remember that even though it modifies no violent or harassing contact, you can still violate your bond conditions if anything escalates beyond that, or if you pick up a new offense, okay?
Yes, Your Honor. Thank you.
All right. Thank you, ma'am.
Thanks, guys.
All right. Thank you, Mr. Riggin.
Your Honor, may I be excused on the Myrie case?
Yes, Myrie is withdrawn.
Okay, thank you.
You're welcome. So far closed or withdrawn or not going forward today are Bell, Downing, Graham, Myrie, Pratt, Virwita, and Worthy. So anybody here on those cases, unless you're on another case on this calendar, you're free to go at this time. I have remaining Cooper, Driggers, Jackson, M. Jackson, and McKinley.
Your Honor,
Yes.
is it about 5 pages long?
What's it say at the top, Mr. Driggers?
I see Superior Court, Clayton County, State of Georgia, petition to seal records.
Right. But it says you can mark out Superior Court and write in State Court.
I mean, it does say State of Georgia.
No. At the top where it says the court. If it says Superior Court, that's upstairs from me. It should say State Court. You just put a line through Superior Court, put State Court.
And what pages do I need to fill out?
Okay, so I think the order is what you have. There's generally a petition, but let's run through this real quick. So I have, Mr. Driggers, that on your case was a 2024 AD 06362. It was administratively dismissed because you participated in the pretrial intervention program and successfully completed it.
Yes, ma'am.
The offense has been dismissed and you're seeking to have it sealed. This, I believe, is sealable. Is there any objection from the state?
No, Your Honor, not this time.
Per that information, then the court will go ahead and grant the motion to seal. Ms. Powell, do you have a copy of the order that was sent, or one of the standard orders that we could, I guess, modify to put his information on there?
Yes, ma'am.
Okay, so Mr. Driggers, Ms. Powell, do you have anything indicating his email address?
Let me check. If it's not on the calendar for today, then no, ma'am.
Okay, so Mr. Driggers, what I need you to do is do not use the chat function.
Okay.
Okay, chat your email, not to everyone. When you see the word everyone in blue, click on that and it'll do a pull down menu. I need you to chat your email to Miss Kiera Powell, Kierra.
So let me see. Click on chat
Right?
and then
Click on the name in blue.
Miss Gordon.
No, you're going to go further down.
Oh, I see everyone. And
Click on that. And then once the pull down menu comes, go down the list until you see Kiera Powell.
okay.
Click on her name and send her your email address.
Kiera Powell, I got you.
Yes. So we're going to go ahead, and once we send that in to the clerk's office, we'll email you a copy. Okay.
Okay. Are you familiar with the airport?
I I know where it is. You
No.
can, if
Well, I
so.
mean, oh, sorry. Go ahead.
Here's what happens with this motion to seal. It's really what directs the clerk's office to hide your electronic footprint.
Yes, ma'am.
So it may take a few minutes. I mean, not a few minutes, but it takes a few days for them to go through the process of putting it behind the computer wall, so that where it's not accessible. If you have a copy of the order that we send you, if you want to present that to anyone that you need to present it to at the airport, you can. But it's going to take a minute before, when they search, they won't see it.
Yes, ma'am. Well,
So
my question is, they put a 2-year, basically a 2-year restriction at the airport.
okay, then that's what the airport did. That's not what we did.
Okay. Well, I didn't know if you
So,
had jurisdiction over the
no,
airport.
ma'am. Oh, no, sir. Not at all. We adjudicate some of the cases that originate at the airport, not all of them. Some of them fall under the federal jurisdiction. Some of them fall under City of Atlanta's jurisdiction, but I don't know who instituted the ban, but you can send them a copy of that and ask that it be removed.
Okay.
I'm not even sure who in the airport would have done that. Whatever paperwork you have may help you with that.
Yeah, I mean, I know his name is
Okay, well, that you don't have to tell us his name,
oh,
but you can send him a copy of your order and request that it be removed. That's between them, but that has
okay.
nothing to do with me.
Maybe you can answer a general question when they say, like, I'm an Uber driver, and so they go,
Yeah, I really can't, because I
okay,
don't know the particulars of what they do. Like I said, I don't have jurisdiction over the airport in that way. So if
okay,
they've instituted a ban, you have to deal directly with them.
okay, all right.
All right.
And I'm good?
Yes, sir. You're free to go at this time.
Thank you, ma'am.
All right. So remaining, I have Cooper. We were preparing for a hearing on that. Are we ready to go forward?
Yes, the state is ready. I know that Attorney Tursactor is his client, but the state is ready.
Okay.
Your Honor, defense is ready as well.
All right. So where's Mr. Cooper? Y'all can sit it. Y'all can come on up. If you need to pull chairs up closer to the computer, that's fine with me too. I want you to be comfortable, if that's okay with
Friday. You sent me a thing to reply Friday. I go there for
Mr. Pullen. Mr. Pullen, I need you to mute. Thank you. All right. This is the state of Georgia versus Nazir Peru Cooper. Mr. Cooper is before the court on 2024 CR 07029 for two counts of terroristic threats and acts. He's before the court for the motion to revoke bond that was filed by the state. The state is represented by Assistant Solicitor Janine Hagler. The defense, Mr. Cooper, is represented by Taz Taylor, attorney from the law firm of Lister, Holt, and Dennis. Both parties have announced ready. The states can go forward. Ms. Hagler, you can call your first witness.
Thanks, Your Honor. And before I do call my first witness, I'm asking the court to take judicial notice that the defendant did receive an order for bond for his terroristic threats charge. It was signed by Judge Kimberly F. as in Frank Bando, B as in boy, A-N-D as in David, O-H, on June 3rd of 2023. And in that order, it is checked that the defendant must not violate any laws while on bond. So asking the court to take judicial notice of that order for bond for that case.
Court, go ahead, Mr. Taylor.
Your Honor, to expedite matters, defense is willing to stipulate to Mr. Cooper's arrest on new charges. I believe that's the basis for the state's motion, and we stipulate not to the allegations themselves, but that an arrest did occur.
All right, so the court does take judicial notice of the bond conditions. The defense is willing to stipulate that Mr. Cooper was arrested subsequent to the implementation of the bond conditions. All right.
And so, Your Honor, with that stipulation, the state is asking that you do revoke the defendant's bond and that he is detained until trial.
All right, Mr. Taylor?
Yes, Your Honor. I would like to present to the court two of the witnesses to the terroristic threats charges. They are each named as the alleged victim in those cases, and they wish to address the court with information that is relevant to the charges at hand. So at this time?
Well, Your Honor, I would object. The witnesses, are you saying for the terroristic threats that you're trying to bring up to the podium?
Yes.
Okay, well, we would object. Again, we're revoking on his new offenses. So unless they are for the new offenses, we would object that the testimony would not be relevant, Your Honor.
So I'm confused. So let me understand. The terroristic threats are the 2024. What was the basis of what was the charge for the 2023 bond condition that was implemented?
The terroristic threats were the 2023 case, Your Honor.
So it was terroristic threats initially, and then another charge of terroristic threats after.
No, Your Honor, another charge. The new charge is of rape, and that was on May 12th of 2024. That is why I filed a motion to revoke bond.
Is what now?
The new charge is for a rape charge, and the incident date is May 12th of 2024, which is why I did file the motion to revoke bond. That is his new offense.
Mr. Taylor? That's a different offense. And I'm not sure that the court has to attack, that the underlying offense has to be attacked, because it's not the motion to revoke bond is not to have any additional charges. In this case, Mr. Cooper has additional charges, and so he would have violated his bond condition by getting arrested on new charges. It leaves it at that point in the court's discretion whether to go ahead and revoke the bond. The bond becomes revocable at that point that he is rearrested. The court can either revoke bond in its discretion because he has violated the bond conditions and possibly presents a risk of either new offenses, additional new offenses being committed, or he is a risk to the community at large or specific witnesses or victims. Or the court can say that it's not something that would cause for community safety to be at risk, and so the court denied the motion to revoke bond. If it's proven that he didn't violate his bond conditions, the court can also deny. But in this case, the state's going forward on him getting additional charges against him, and in that case, it's a much simpler burden of proof. You've already stipulated to the fact that he was subsequently arrested. And while I thought we were talking about an additional misdemeanor charge of terroristic threats, he has not only the misdemeanor charge of terroristic threats, but a felony charge of rape.
Well, there's not an additional charge. He was charged with 2 counts of terroristic threats.
One in 2023 and one in 2024?
No, Your Honor.
What's the 2020? So, Mr. Taylor, this is what I'm asking. If Judge Bando, who trained with me and knows her stuff, if she gave him a bond at first appearance in 2023, then there has to be a charge. So what you're saying is the terroristic threats happened in 2023, but wasn't accused until 2024. Is that what you're telling me?
Well, the two charges of terroristic threats were for one incident, one alleged incident with two victims that occurred in 2023.
Okay, so Judge Bando gives the bond conditions on the case in magistrate court. By the time it goes up and gets accused, it's accused as a 2024. That's what you're telling me.
Yes, Your Honor.
Okay, but then what Ms. Hagler is saying is that she's proceeding on the fact that he got bond conditions for the terroristic threats, but he also has a subsequent arrest for rape, a felony. So the rape arrest would have been the violation of the bond conditions, not the terroristic threats.
Yes, Your Honor. And we, as I said earlier, we did stipulate to that arrest. However, we wanted the victims of the terroristic threats to.
But Mr. Taylor, that's not how this works.
Likelihood of conviction of an underlying offense, the underlying offense and the likelihood of conviction is relevant to this, Your Honor. The victims here are prepared to testify that the event of terroristic threats to which they are the named victim did not occur. They are the witness. Okay,
but Mr. Taylor, I get that he has the right to a defense. What I'm not going to do on a motion to revoke bond is try the case. If it were the situation where he was saying that he did not have contact with the person that was named in the bond, and he can show he did not have contact, and the state is trying to prove that he did have contact with somebody named in the bond, that's a different issue. I'm going to hear evidence on both sides and then figure out if, in fact, he did have contact in violation of the order. In this case, it's much simpler. All he has to do to violate the bond order is to be arrested on an additional charge. That has happened. What I'm not going to do is, without benefit of a trial, try the case about the underlying terroristic threats. I'm going to tell you, Mr. Taylor, as until I hear it in a courtroom and I'm the trier of fact, because generally I'm usually the trier of law. So it doesn't matter to me what the witness says, as long as it satisfies a jury. In this case, I will not sit as the trier of fact on the underlying offense of terroristic threats, because he has a right to be tried by a jury. And so I'm not going to sit here and say those charges were not sufficient for an arrest. I'm not sitting in the stance of a probable cause hearing. If he had a probable cause hearing in magistrate court, they would have had the right to reduce those charges or dismiss those charges. If he didn't have the probable cause, if he waived it, or if they didn't dismiss or reduce, I'm not going to turn this into a probable cause hearing. It's either he got arrested or he didn't.
Yes, Your Honor.
In this case, he got arrested. So at this time, the court is going to grant the motion to revoke bond. Mr. Cooper is going to be taken into custody and held until such time as his charges before this court are resolved.
Your Honor, may I have 15 minutes to speak with Mr. Cooper to determine if we are going to enter a plea to the Senate's recommendation?
He can be arrested and go into the booth. If they put him in the booth, then that's fine, but he goes behind the door now.
Yes, Your Honor. She's not going to hear it.
All right, so motion to revoke bond for Cooper has been granted. The state will prepare an order for immediate arrest.
Yes, Your Honor, thank you.
All right, in the case Jackson, Alred Jamar Jackson, Mr. Jackson has two cases pending, a 2021 and a 2024. Motion to revoke bond has been filed.
Judge, and he still intends to enter a plea. We're ready to go forward, except for I'm just still waiting to make sure I can tell him all the conditions.
Yes, right now, case ending in 00217, count 1, 12 months to serve, 10 days, balance probated. He needs to complete the substance abuse and alcohol evaluation and treatment, and the drug or alcohol risk reduction program 40 hours of community service, a fine of $500, no drugs or alcohol, and one AA meeting per week. That's count one. Count two, a fine of $200 to be suspended. Count three, a fine of $200. And then count four, a fine of $100. And then for the other case ending in 05750, 12 months probation, a fine of $300, 40 hours of community service, and to complete the family violence intervention program. And then count two would be non-pros.
And that is to run concurrent with the other case, or?
That's fine, that's fine.
My client has indicated that he would like to take this plea under the First Offender Act. I believe he's eligible. Is there any objection?
Which part? Both of them?
No, that obviously I understand that the DUI charge is not eligible for first offender. I'm saying the family violence case. The simple battery family violence.
If he's eligible and wants to use it, I don't have an objection.
Judge.
Yes.
Yes, Judge. That is we're prepared to go forward on the plea.
And there's 3 cases, right?
Yes, Judge. The other case is not on the calendar. We would like to address that case separately. That is I understand is one of the basis for the motion to revoke bond. However, he hasn't. I don't believe he's been arraigned on that. He does wish to present a case. I mean, a defense in that.
What's the third charge?
It's a reckless conduct. It has absolutely nothing to do with either of these cases. And he intends to present a self-defense or defense of others defense in that case. And so we would just ask that he be allowed to handle that separately now that he has resolved these 2 older cases. The reckless conduct case is brand new.
Yeah, it's a felony.
The reckless conduct?
Yes, that's when I filed the motion to revoke on.
No, I'm saying I thought I saw it on my calendar the other day. So it's the reckless conduct this felony reckless conduct?
Yes, Your Honor. Let me just make sure based off of what I
thought it was a misdemeanor as well.
Sorry, it's misdemeanor. I'm sorry. Yeah.
Okay. Yeah, because I remember seeing it on my calendar because I was fussing at this young gentleman who seems to not be able to get it together. 1 second.
Okay. And Attorney Lynch, while the judge is off the bench, I am going through his criminal history. It appears that he may have had a felony. Can you just confirm? Because if he had a felony, he won't be able to use the first offender. I'm showing a failure to appear felony for kidnapping. So he might not be able to use first offender if he has a felony. Just to give you a heads up.
He's indicated he's never been convicted of any kidnapping offense.
Is that, it's on a history, so.
But as a conviction?
It says the failure to appear. I don't see the conviction because it happened in 2012. So I can't see it on here, but it does say failure to appear felony for kidnapping. Just to give you a heads up. So he may not be eligible.
Well, so I believe he is eligible because he has not been convicted of a felony, and there's no felony pending.
Well, I don't know if he's been convicted or not. Like I say, it's an old case. I don't see it on my GCIC.
Okay. You're safe.
But we're ready to proceed, Your Honor.
Okay. I don't think I have to deal with the reckless conduct right now because it's not before me. If he wants to do it under first offender, that's fine. But if he's ineligible for it, it's not going to go through.
We understand that, Judge.
Okay. All right, Mr. Jackson, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true. You can put your hand down. You're before the court on 2021 CR 06126, Allred Jamar Jackson. You're represented by the law firm of Lister, Holt, and Dennis. Mr. Owen Lynch is with you at the podium. You're charged in this case with simple battery family violence, count 1, simple battery, count 2, simple battery family violence, count 3, and simple battery, count 4. How does your client plead to the offenses before the court, Mr. Lynch?
Judge, it was a guilty plea under the First Offender Act to count 1. And I believe that was the only plea that the state required in that matter.
All right. So counts 2, 3, and 4 will merge.
Yes, Your Honor.
All right, and on the case 2024 CR 03196, DUI drugs, improper lane change, impeding traffic, drug objects, distracted driving, seatbelt violation, and marijuana 1 ounce or less. How does your client plead to the offenses before the court?
So it's a guilty plea to count 1, Judge. Nolo plea to count 2, and I believe a guilty plea to count 3. And the state wants a guilty plea on count 4. And what we're pleading to, I know the state's going to no pros count 7, but we'll plead to, which did you indicate you were going to no pros another count other than 7? I know he's pleading to every other count.
Yeah, that's fine. Yep, that's fine.
What now?
So guilties. So count 7 is no pros. Guilties to 5 and 6.
All right. On case 2024 CR 03196, by entering a plea of guilty to counts 1, 3, 4, 5, and 6, and a Nolo plea to count 2, count 7 will be no pros. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, Mr. Jackson?
Yes, ma'am, Your Honor.
All right, factual basis and recommendation, please.
Yes, Your Honor. And also for the record, unfortunately, I did read off the wrong recommendation, but again, it's still no jail time, Mr. Attorney Lynch. But again, 1 second, let me go to the.
Is this for case 1 or the second case?
For both. So for case number 2021 CR 06126, let me get the factual basis. And like I say, it's still no jail time because he completed whatever time already. Let's see. So on or about July 8th of 2023, Clayton County, Georgia, Officer Mueller did see the defendant driving a silver Chevy 1500 on Highway 85. He saw the defendant swerving from the turning lane into the roadway and then slowed down. By impeding the flow of traffic on Highway 85, Officer Mueller got behind the vehicle, conducted a stop. He did notice that the defendant was not driving a seatbelt. During his investigation, while speaking to the defendant, he could smell a smell of odor of alcoholic beverage coming from his person, as well as the odor of marijuana. The defendant had slurred speech. the defendant did agree to standardized field sobriety tests in which he failed all those exercises. The defendant, Officer Brumaller, did locate marijuana off the defendant as well. Your Honor, for count one, the state's offer is actually 12 months to serve, 4 days, credit time served, balance probated, a fine of $500, 40 hours.
This is on the simple battery case?
Oh, sorry. Simple battery, the fine is 12 months to serve, 3 days, community time served, balance probated. And then a fine of $500 to complete 40 hours of community service, to attend the firearm safety class, to forfeit his weapon. And that's it for that count.
Are you sure you didn't read possibly a recommendation?
Okay.
Reckless conduct
These
case?
don't make sense. So here's the problem. With the battery, there should be some anger management or family violence intervention.
With that one, let me go back to the facts.
Yeah, just slow down, Ms. Hagler. We're not rushing. Just go ahead. So you got 3 files for Mr. Jackson. It can be confusing. Let's go ahead and find the one for the battery and the one for the DUI.
All right, I think here we go. Okay. And again, thank you for your patience. On or about March 30th of 2024, Officer K. Pullin, Pullin, was dispatched to 5991 Riverdale Road, Atlanta, Georgia, 30274, Clayton County, in regards to a disturbance. When he arrived, he made contact with the defendant. He stated that he shot at another subject that was attempting to enter his vehicle while in the store.
You're reading a factual recommendation for the reckless conduct charge.
No, this is the simple battery.
Are you sure? Because that sounds a lot
Jackson, right?
Yeah, the fact.
Wrong Jackson?
No, it's the right Jackson, but it's the wrong case. That's the that has to be the reckless conduct case. The simple battery case does not involve a firearm.
I don't have a reckless conduct on my calendar. Hold on.
It's not on the calendar.
The first name is Alrad, right?
Yes, it's the right defendant, but that simple battery case does not involve a firearm.
Okay, 1 second, but that's, I don't, let's see. Oh, 6126. One second. Okay, gotcha. Here we go. All right. Okay. So on or about May 20th, 2021, Officer J. Mustafa completed a proper cause affidavit for battery, family violence, and simple battery against the defendant. Officer Mustafa was called out to 8146 Huntington Drive, Jonesboro, Georgia, Clayton County. Pursuant to the probable cause affidavit, the defendant attacked his nephew, Malachi Jones, by pushing him to the ground, punching and causing visible injuries to his left hand, his pinky on his left hand. The defendant also punched his mother, Carolyn Jackson, on the right side of her head. And this incident did occur in the presence of the defendant's sister, Bernadette Jackson. The defendant did live with Carolyn and with Malachi at the time of the incident. So Your Honor, for count one, it's 12 months probation. 12 months probation to complete the family violence intervention program, 40 hours of community service, no violent or harassing contact with the victims, Malachi Jones and Carolyn Jackson, and a fine of $300. Counts 2 to 3 will merge, and then count 4, 12 months probation, a fine of $100, and to have no violent harassing contact again with the victims, Malachi and Carolyn.
Okay. All right.
All right. For the second case, ending in 3196. Okay, I went earlier. I think I read those facts already, Your Honor. So again, the recommendation for that one, okay, is going to be count one, 12 months to serve, 4 days, community time served, balance probated, a fine of $500, 40 hours of community service to complete the drug risk reduction program, random drug screens, the substance abuse evaluation and treatment, and follow their recommendations, no drugs or alcohol, and to attend 1 AA meeting per week or NA meeting per week. Count 2, a fine of $100. Count 3, a fine of $100. Count 4, a fine of $300. And then the state will not prosecute counts 5 through 7.
All right. Anything else, Mr. Lynn?
Nothing at this.
All right. So on the case 2023, I'm sorry, 2021 CR 06126, sir, I'm going to accept your plea of guilty to count 1 and count 4 under first offender statute. On count 1, I'll sentence you to 12 months to probation to take a family violence intervention program class, 40 hours of community service. You're to have no violent or harassing contact with Caroline Jackson and Malachi Jones. You'll pay a fine in the amount of $300, $444 with the surcharges. Is that what that will total? On the count 4, 12 months to serve, 12 months to serve on probation, $100 fine, which will be $151.50 with the surcharges. That's the total for that. And no violent or harassing contact. That will run concurrent with count 1. And those are all under first offender. On the next case, 2024 CR 03196. On the first count 1, 12 months, 4 days, credit for time served. Balance will be probated for you to pay a fine in the amount of $500. It's going to be closer to $1,000 because of the enhanced fees from the state before DUI. You'll also have 40 hours, additional 40 hours of community service. You're to take a risk reduction course, have no alcohol or illicit drugs during the course of your probation, and you will be tested randomly for alcohol and drugs. You're to take a substance abuse evaluation and any treatment that may be ordered. You'll do 1 AA or an NA, so 1 Alcoholics Anonymous or Narcotics Anonymous class per week, and show proof of that to your probation officer. Count 2 will run concurrent with count 1. It's an additional fine of $100. That's $151.50 with the surcharges. Count 3 will run concurrent with count 1. It's another $100 fine, $151.50 with the surcharges. Count 4 is a $300 fine. That's an additional $444 total. That will run concurrent with count 1, and counts 5 through 7 will be no pros per the motion of the state. Mr. Lynch, anything on behalf of Mr. Jackson?
Nothing at this time, Your Honor.
Mr. Jackson?
Yes, Your Honor.
It's a lot cheaper and a lot less of a taking away of your time and freedom to toe the line. You got a lot going on here, sir. It's a lot of money, but it's also a lot of a time commitment. You got classes that need to be done. You have community service, at least 80 hours of community service as I'm counting. So please don't, if you get in the weeds and you're having issues, the last thing you need to do is skip probation reports. The first thing that will get you arrested is not reporting to probation. And I've said this over and over again. I'm giving you all the cheat codes for how to be successful on probation, and people still won't show up. I guarantee you, if you fail to show up for probation, that is where they will send me a warrant, quick, fast, and in a hurry. Are we clear? Yeah. If you have any issues completing any of the fines and fees or any of the terms and conditions of your probation, talk to your probation officer. They will help you work it through. But if you just don't show up, you are definitely going to jail. Yes. All right. So when you leave the courtroom, you're going to go right, take a right, go into courtroom 305. The first double doors, when you walk through the first set of double doors, there'll be an office and the probation expert will be in that office. Miss James, if she's busy with somebody, just wait till the hallway until she calls you. She will do your probation intake, ask any questions that you need to ask about probation, ask it about anything that involves your work, your travel, anything that's currently going on in your life that could be a hindrance, but understand that probation is the priority because I could always put you in jail. Yes, ma'am. All right. And that's not a threat. It's just that when I tell people I'm putting you on probation, you have the freedom to work and continue your life as long as you do these things. People still mess up on probation. I can put you in jail if probation is not for you. That's all I'm saying. All right. So go on outside and meet with Miss James. And after that, you can leave. All right. Then Mr. Jackson, please continue to remember that you are still under bond conditions that require you to not have any additional offenses. All right, so McKinley. Motion for immunity?
Yes, Judge.
We ready?
We're ready. Defense is ready. I'm not sure if the state, Ms. Hagley, you're muted.
I'm sorry, let me confirm. Investigator Pugh, are the officers on for that case? You can send me a chat if you need to.
All right, ladies and gentlemen, we have one more.
Listen,
I'm sorry.
I was talking to my investigator. You're good, Your Honor.
Ladies and gentlemen, we have one more motion on the 10 a.m. calendar, and then we'll move to the 11 a.m. calendar. I'll call that calendar in a moment.
Yes, ma'am, they're on. ASG Hagley.
Thank you. Let me get the 1 second. I'll locate the file. Give me 1 second. And I am ready, Your Honor.
All right, this is the motion for immunity filed by the state. Filed by the defense on case 2022 CR 00680, Sierra Michelle McKinley. Ms. McKinley is represented by the law firm of Lister, Holt, and Dennis. She is represented by attorney Owen Lynch from that law firm. The state is represented by attorney assistant solicitor general Janine Hagler. Both are present and prepared to go forward at this time. Mr. Lynch, are you ready?
Yes, Your Honor.
All right.
Defense calls Sierra Michelle McKinley. Ms. McKinley, will you please raise your right hand? Do you swear or affirm to tell the truth, nothing but the truth, under penalty of perjury in this matter? Ms. McKinley, you can lower your right hand.
Hold on a second, Mr. Lynch. Ms. McKinley, you've been sworn, and this is a motion for immunity from prosecution. This motion was brought by your attorney. Please understand that you and your attorney, I'm sure, have discussed your opportunity to present evidence and testimony in this hearing. But I have to remind you that you have a Fifth Amendment right against prosecution, against a Fifth Amendment right against self-incrimination that prevents anyone from forcing you to testify or promising you anything to get you to testify in any case. Please understand that if you testify in this case, you have to voluntarily waive your right to remain silent to offer that testimony. And once you do that, any testimony that you give can be used in any prosecution of any pending matter against you or any matter subsequent to this. So you understand that your words can be used against you, but you're not being forced to give any testimony. So do you understand that you have a right to remain silent?
Yes, ma'am.
And you understand that in order to make this testimony, you have to give up that right to remain silent?
Yes, ma'am.
And you understand the consequences could be that they could use your own words in a prosecution against you?
Yes, ma'am.
All right. And have you don't tell me what you spoke about, but have you had the opportunity to discuss this with your attorney?
Yes, ma'am.
And you still wish to go forward?
Yes, ma'am.
All right, Mr. Lynch, your witness.
Yes, ma'am. So, who is Antoine Carroll to you?
He is the father of my children.
How old are your children?
3 and 4.
What are their names?
Anaya Carroll, Imani Carroll.
I want to take you back to February 24th, 2020. Do you recall getting into an altercation with Antoine Carroll on that day?
Yes.
Can you please explain to the court what happened in that altercation?
That night, Antoine was upset about our rent payment. I came in from being out to grab something to eat and coming from the nail shop. He was upset. He asked me to leave. He said he was not satisfied in a relationship. I was kind of confused. I was taken aback. Before long, the altercation, the argument became a physical altercation. In the process of me gathering my things and trying to leave, Antoine jumped on top of me while I was 6 months pregnant. He was trying to get the cell phone that he had just purchased for me maybe a day or two before out of my hand. He was on top of me wrestling. I was trying to, get him off of me. So the phone was in my right hand. He had one hand around my neck and the other hand trying to control me, trying to control my movement. At that point, I struck him in the eye, under the eye, with my right hand. The cell phone was in my right hand, so I struck him with the cell phone in his face. He got up. I was able to get up and retrieve my things and exit the apartment. Upon exiting,
You can keep going.
Upon exiting the apartment, he locked me out.
Okay. And what were you wearing at the time when he locked you out of the apartment?
Bra and some panties.
And what was the temperature outside?
About 40 degrees.
So just going back to the physical altercation that you described, prior to that altercation that you described, had there been any prior physical contact?
No.
Did you hit him in the face with a bottle at any point?
No.
And you said the only, let me ask you this. He initiated the physical contact by jumping on top of you. Is that correct?
Objection, leading.
How did he initiate the physical confrontation?
He asked me for the phone and I refused. The phone was my only way to contact anyone. I'm not originally from Georgia, I'm from Louisiana. So I felt being that I was alone, I needed my phone and he was trying to take it and I wouldn't give it to him and attack me.
Excuse me, Mr. Durham, could you please mute your microphone?
Oh, yeah.
When he jumped on, well, can you describe to the court the contact that happened with your stomach region?
He pretty much jumped on top of me, like straddled me. He was on top of my stomach. At the time, we both was aware that I had preeclampsia. I was a high risk pregnancy. So once I was outside, I believe Antoine called the police, but I took an Uber to the hospital because I was in pain.
And as a result of, well, when you went to the hospital, did you end up speaking to a police officer at the hospital?
Yes, so after registration, I was notified by the hospital that they was obligated to call the police, being that they found out that I was in a physical altercation with the father of the child. They were by law obligated to call the police to the hospital. So the police was dispatched and they came to speak to me while I was pretty much already hooked up to wires. I was already admitted.
Right. And did you tell the officers everything you told me?
Yes.
As a result of the contact with your stomach at the time you were 6 months pregnant, can you describe to the court what the results of that were?
Objection relevance.
It's relevant because this is an injury from an attack that necessitated self-defense, not only herself, but she had to defend her unborn child. And we're here about a self-defense motion. And so the fact that there was an injury to the fetus is
overruled. Go ahead, Mr. Lynch.
You can answer the question.
Once I was admitted to the hospital, the next day I was told that I would have to stay until the birth of the child. They were trying to push me to at least 8 months. At the time, I was 6 months. My daughter was due on May 25th. She came on March 12th. This was due to the physical altercation. I was advised to stay in the hospital until the birth of the child. Once my child was born, she was born 29 weeks and 4 days. She was 1 pound, 9 ounces, and she was born with a neurological disability.
What is that neurological disability?
She pretty much has a muscle that is not completely developed in her bottom lip. So when she talks, she cries, or any type of movement with the face or the mouth, her lip resorts to the left side of her face.
Okay, thank you. Just a few more questions. I'm going to go back to the physical altercation. When Mr. Carroll jumped on you and wrapped his hand around your neck, what, if anything, were you thinking about at that time?
Getting out of there alive.
Thank you. No further questions.
All right. Any cross-examination, Ms. Hagler?
A few, Your Honor. So is it your testimony today that you never told the police officers that you threw a bottle or hit the victim with a bottle, a Evans Williams glass bottle? Is that your testimony today?
I never hit or threw a bottle at him. While we was in the house, the bottle was not in the house. The bottle was located outside of the apartment near the trash.
And you testified that when you gave birth that your child has you said neurological disability?
That is correct.
Okay. Did your doctor or your physician tell you the cause of that disability?
They did not. Prior to the incident, we already knew that I was pretty much a high-risk pregnancy. We didn't know that our child would be born early or premature or even with a disability.
Okay. Thank you. No further questions.
Can you redirect Mr. Lynch?
No, Your Honor.
Any other witnesses?
The defense does not have any additional.
All right. Ms. Hagler, any witnesses on behalf of the state?
Yes, Sharon, at this time, the state would like to call Sergeant Francis Willis, please.
All right.
And can you please turn your, okay, perfect. Can you please go ahead and raise your right hand?
Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, your witness, ma'am.
Thank you, Your Honor. Sergeant Willis, can you please state your first and last name for the record?
Sergeant Francis Willis.
And can you please spell your first and last name for the record?
Francis, last name Willis.
Okay. And how are you currently employed?
I'm a supervisor down here in Lovejoy, City of Lovejoy Police.
Okay. And were you employed with the Clayton County Police Department on February 24th of 2020?
Yes, ma'am.
Okay. And did you respond to 228 Morrow Road, apartment 13F, Forest Park, Georgia, 30349?
Yes, ma'am.
Okay. And what was the nature of that call?
It was a domestic disturbance. I'm trying to pull up the report now. It was a domestic disturbance.
And upon your arrival, who did you make contact with first?
At the residence, I spoke to Mr. Carroll.
Mr. Carroll, okay. And what did Mr. Carroll tell you?
It's okay if I refer back to the supplemental. This was a while ago. My supplemental report.
Yeah, so your report can refresh your
read
memory?
from it, sir, but you can refresh your memory, and when you're finished, just look up.
Correct. Mm-hmm.
Okay. It's here in my email, just a few years ago.
Okay. Yeah, whenever you're ready, after your memory has been refreshed, let me know. I can continue with the questioning.
Okay. Okay, I'm ready.
Okay. And what did the Mr. Carroll tell you?
Mr. Carroll stated that he was in a verbal altercation with Miss McKinley, and during the altercation, she allegedly punched him in the face, and therefore he told her to get out of the residence. And when she walked out, he did lock her out. She began to damage the windshield of his vehicle, and while she was damaging the vehicle, he realized that she was not fully dressed. That's when he opened up the house again, and she returned to the residence, and she threw a bottle at him, striking him in the face.
Did he tell you what kind of bottle was thrown at him?
I don't recall.
Okay. Were you able to observe any injuries to the victim?
He had an injury to his eye. I believe it's his left eye.
Okay. What was the injury that you observed?
It was a cut and some swelling.
Okay. Did the victim tell you anything else as far as the incident?
No, ma'am. Not that I recall.
And is the victim in this case Mr. Anton Carroll?
Yes, ma'am.
And did you speak to anyone else during your investigation on that day?
Initially, I did go to the hospital and speak with Miss McKinley.
Okay. And what did she tell you?
They were in an argument about finances, and they wanted to speak about, I believe it was text messages. She said that he was texting her, calling her out of her name, saying she was an a-hole. When she got to the house, that's when the verbal altercation occurred. And as she stated today, she alleged that she was choked and Mr. Carroll had jumped on her stomach. And that's when she was locked out of the residence. And then she called an Uber to take her to the hospital because of the physical altercation that they had, that Miss McKinley and Mr. Carroll had.
Okay. And then during your investigation, did you see any glass or broken bottles throughout your investigation on that day? Do you recall?
I do not recall.
Okay. During your investigation, did you speak with anyone else?
The primary officers, I do not recall which officers were out there.
Okay.
I was there as assistants.
Okay. And during your investigation, were you able to determine who was the primary aggressor?
I believe that was the primary officer that made that determination.
Okay. Gotcha. And in speaking to the defendant, did she make any claims of self-defense to you when you spoke to her?
I do not recall.
Okay.
Just looking at, I looked at my supplemental. I don't remember any self-defense claims.
Gotcha. Okay.
Just that only that she did not call 911 when it happened because she wanted to get away from the residence. She wanted to get away from Mr. Carroll.
Okay. Your Honor, no further questions for Sergeant Willis.
Sergeant Willis, did you see her at the hospital?
Yes, ma'am.
Did you talk to anyone who saw her when she came into the hospital?
We've spoke to the APD officer that was out there at the Emory Hospital.
Was she dressed?
I'm sorry.
Was she dressed?
I do not recall if she was dressed being at the hospital.
Okay. All right. Mr. Lynch, you have any other follow-up questions?
I do. Sergeant Willis, you indicated you don't remember if my client made any claims of self-defense when you talked to her. Would it refresh your recollection to look at your supplemental report as to whether my client made claims of self-defense?
I could look at it again. I just looked at the part with Mr. Carroll.
Take a look specifically, and I believe the second to the last sentence in the first paragraph of your report.
Okay, I do see it.
So now that your recollection is refreshed, isn't it true that Ms. McKinley claimed self-defense in striking Mr. Carroll?
Yes.
And isn't it true that she stated to you that he had his hand wrapped around her neck?
Yes.
And isn't it true that she stated that after that altercation, she tried to escape the room?
Yes, I do recall that.
And did she tell you that she was locked out at any point?
Yes. They both stated that.
Right. Did you ask Mr. Carroll about the allegations that he jumped on Miss McKinley's stomach and wrapped his hand around her throat?
That I do not recall. That's not in the, well, I only have my supplemental.
When you're conducting an investigation like this, isn't it important to get both sides of the story?
Yes, it is.
But your testimony is you don't remember whether you asked Mr. Carroll about his part of the physical altercation. Is that true?
That's true. And however, there were multiple officers out there. And as I stated, I was not the primary officer who made the determination.
Understood. You didn't, well, you said you did not observe any broken glass inside of the residence. Is that correct?
Yeah, I didn't recall.
You don't recall? Okay. No further questions this time.
All right. Any redirect?
Just one, Your Honor. And so Sergeant Willis, you did indicate that the defendant did say self-defense. During your investigation, was there anything consistent about the crime scene that led to self-defense based on your investigation?
That I cannot remember. I cannot recall if it's like broken glass or just the injuries that were visible. Other broken glass, torn up house. I couldn't recall that.
Okay. Thanks, Your Honor. No further questions.
All right, so Sergeant Willis, I have one other question. So, is it fair to state that sometimes if people are involved in an altercation that becomes physical, some injuries may be visible, but some injuries may not be visible?
Yes, ma'am.
All right, and the arrest of on a battery charge generally depends on whether the injuries are visible to the officer making the observation.
Yes, ma'am. Battery has to have a visible showing.
Okay, and so when there's been a determination being made of whether either it's mutual combat or trying to determine who the primary aggressor is, generally what the officer will be looking for to charge battery is whether either party has visible physical injuries. Is that correct?
Yes, and in addition to physical injury, if both parties have physical injury, who's the predominant primary aggressor, who's continuing the physical altercation unnecessarily? Even in the claims of self-defense, if somebody gets slapped, the victim would become the primary aggressor, predominant primary aggressor, by pulling a gun and shooting someone that slapped them, to give an example, going beyond what is reasonable self-defense.
All right. And so the reason I asked about the clothing is in the recounting the case, the alleged victim in this case says that she came back into the place once he realized that she was not properly dressed for the weather. And the testimony of Miss McKinley is that she was pushed out and only had on underwear and her phone. Do you have anything in the record that you have access to that reconciles whether she came back into the house and was able to dress, or whether she was still in clothing that was not appropriate?
And that I do not recall. I don't remember how she was dressed in the hospital.
Right. Well, by the time you got to the hospital, she may have been dressed differently. Is that true?
Possibly, yes, ma'am.
Okay. All right. Any other questions from the state?
No, Your Honor. Thank you.
Yeah, I do have one follow-up question based on the questioning from the court.
Okay.
Officer, you testified about self-defense and what a reasonable response would be. You gave the example of if somebody shot someone, or if somebody was slapped, they can't, the person who was slapped can't use a gun in self-defense. That wouldn't be reasonable. That was the example you gave, right?
Just a brief example, yes.
So let me just go to the facts of this case. As reported to you, if someone was being choked, if someone had a hand around their neck, would a strike to get out of that situation, would that be reasonable force in your opinion, based on your training and experience?
In my opinion, yes.
Thank you, sir.
Okay.
That's all.
All right. Does the state have additional witnesses to present?
Yes, at this time, the state would like to call Sergeant Cameron Ritchie.
All right. All right. And may Sergeant Willis be released at this time?
Yes, Your Honor. Thank you, Sergeant Willis.
Thank you. Have a good day.
You too.
Sergeant Whitty? Ritchie, I'm sorry. Sergeant Ritchie, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
I do.
All right, you can put your hand down. You're witness.
Thank you, Your Honor. Can you please state your first and last name for the record?
Yes, ma'am. Sergeant Ryan Ritchie.
And can you please spell your first and last name for the record?
Yes, first name R-Y-A-N, last name R-I-C-H-E-Y.
Thank you. And Sergeant Ritchie, how are you employed?
I'm a sergeant with the Clayton County Police Department.
And were you employed with the Clayton County Police Department on February the 24th of 2020?
Yes, I was.
And did you respond to 228 Mara Road, apartment 13F?
Yes, I did.
And what was the nature of that call?
It was a domestic disturbance.
And upon your arrival, who did you make contact with first?
I made contact with Mr. Carroll.
Okay. And what did Mr. Carroll tell you?
He stated that
I would
him.
object as to hearsay unless Mr. Carroll's going to testify.
Isn't Mr. Carroll the victim?
Correct.
He is a
All right, well, the previous officer just testified to what he said, didn't he?
He did, Your Honor. Yes.
All right, so overruled.
Thank you, Judge. And what did Mr. Carroll tell you?
He stated that him and Mrs. McKinley were in a verbal altercation about the rent money, and during the altercation, she struck him in the face with an empty Evan Williams bottle, and I observed the injuries to his face.
Okay. What injuries did you observe to his face?
It was a small cut and swelling to the underside of his right eye.
And during your investigation, did you observe or collect any bottles?
I don't recall.
Okay. And did Mr. Carroll tell you anything else as far as what happened?
He also stated that she went outside and used the bottle to break the windshield of her vehicle in the parking lot, and then damaged the front door with the bottle by hitting the door with the bottle.
Did you see any damage to the windshield?
Not that I recall. There should have been pictures obtained in our investigation.
Okay. Did you see any damage to the door during your investigation?
Yes, I do recall damage to the door.
And what damage did you observe?
I'd have to take a look at the pictures to tell you exactly what the damage was.
Okay. Did you speak with anyone else after speaking to Mr. Carroll?
No, ma'am. Because Miss McKinley had left the scene in an Uber. I was not able to get in touch with her.
Okay. Okay. During your investigation, who did you determine to be the primary aggressor?
Miss McKinley.
And why?
Just because she wasn't on scene during my investigation, and I observed the visible injuries.
Okay. And during your investigation, was the crime scene consistent with self-defense during your investigation?
Not that I can recall.
Okay. Thank you, Your Honor. No further questions for Officer Ritchie.
Sergeant Ritchie, Mr. Lynch, you have cross-examination questions for this gentleman?
Just very briefly. So other than that initial investigation when you responded to the incident location, was there any follow-up investigation that you conducted?
Not by myself. I just obtained the warrants.
Did you speak to any other police officers who may have been investigating the case later?
Not that I can recall, but that would have been right at shift change when the other officers were coming into work.
Did you learn in your investigation anything about the injuries to my client?
No, sir. Not that I recall.
And you never got any statement from my client, correct?
Correct.
That's all I have.
Sergeant Ritchie, did you learn from the alleged victim in this case that Miss McKinley was pregnant?
Not that I can recall, Judge.
And did you, so you said that he told you that the windshield was damaged by a bottle, but did you see anything, generally if somebody, like as an officer, you're trained to notice certain things, is that correct?
Yes, ma'am.
And so I know from my experience, if I see somebody with a crack in their windshield that's over 2 inches, I'm concerned that they're going to get a ticket because you get close to that 3-inch mark, that's an offense. Am I right?
Yes, ma'am.
Okay, so if somebody took a bottle and struck a windshield, do you think you would recall if there was damage to a windshield?
Yes, ma'am.
And in this case, you said that you don't recall there being damage consistent with a bottle striking a windshield.
I mean, I would have to take a look at the pictures that were obtained on scene.
Okay, because either the bottle is going to give or the windshield is going to give.
Right.
Okay. You said there might have been damage to the door. Could that damage have been consistent with somebody trying to get back into a home if they're out in the cold?
It could have, yes, ma'am.
All right, Mr. Lynch, did you have anything else at this time?
No, I do not.
Ms. Hagler, did you have anything else at this time?
No, Your Honor.
All right. All right. did y'all, is it okay to release, Sergeant, Ritchie?
Yes, Your Honor. Thank you, Sergeant Ritchie.
Thank you, sir. All right, did the state have additional witnesses at this time?
No, Your Honor, at this time, the state rests.
All right, argument, Mr. Lynch, Ms. Hagler.
So I think Ms. Hagler would go first in this case, since we have the burden. That's consistent, right?
All right, Ms. Hagler.
Yes, Your Honor. At this time, the state will ask that you deny the defense motion for immunity from prosecution. Based on the testimony that we heard, both officers did testify that the defendant was the primary aggressor in this case. According to Officer Ritchie, when asked on direct, he did indicate that during his investigation, he did not see anything that was consistent with the claim of self-defense. Additionally, Your Honor, the defendant even testified herself that even prior to the incident, she was already high risk pregnancy. Regarding any type of disabilities that her child does have, we will argue that there's no proximate cause. She couldn't even tell us, what was the cause of that disability. And so for those reasons, we do ask that you do deny the defense motion. Her actions, again, she was determined to be the primary aggressor on this day. Thank you.
Mr. Lynch?
Yes, Your Honor. The standard for self-defense that needs to be proven in an immunity motion is a preponderance of the evidence. You have heard the sworn testimony of Ms. McKinley. In that sworn testimony, after the first officer that was called refreshed his recollection, was entirely consistent with what she told him at the hospital, which is consistent with her being injured in the way that she claimed. That her testimony has not been controverted. I would point out that the state had the opportunity to call to the alleged victim who is on this call, and they chose not to do that. Additionally, Your Honor, so essentially our argument is going to be that we have met the standard of preponderance of the evidence. You are the finder of fact in this case, as you are aware, and there has been no impeachment, nothing presented that would undermine my client's credibility. And I would argue that without anything contradicting what she stated, with the consistency, what she told the officer who responded to the hospital, the fact that she did go to the hospital, the fact that she testified about an injury that she attributes to this trauma that she endured. Additionally, the state argues that there was nothing consistent with self-defense. We all know that, well, I would argue that the court can take judicial notice that, first of all, they didn't see her body, so they couldn't determine whether there was any bruising or anything around her neck. They're going solely on the claims of Mr. Carroll. And again, if the state wanted to get Mr. Carroll's side of it, the state could have presented Mr. Carroll's testimony. Mr. Carroll is on this call, Mr. Carroll, and they did not do that. And I would submit that there's a reason for that. And so, Your Honor, I would argue that the defense has met the burden, and we would ask that these charges be dismissed against Ms. McKinley, because under the circumstance, she was acting in self-defense, and the evidence presented to this court establishes that by a preponderance of the evidence. Thank you.
All right. So in this case, the preponderance of the evidence, well, first, let me go back to probable cause. So the probable cause for the arrest, I think the police officers on the scene made the decision that was appropriate at the time with the information that they had at the time. They had an alleged victim. He had given a statement stating that he had been in an altercation and had the altercation, once it turned physical, that he was the victim of an attack, either from a bottle, principally, and they did notice visible injuries. And so consistent with the statute, that what was done on the scene, it was proper per what the officers were dealing with. However, Sergeant Ritchie did indicate that the part of the reason that he was able to make that determination was because Miss McKinley was no longer on the scene, and that he didn't have any evidence consistent with what she might have said in this case. The one thing that is glaring to me is you have someone who's 6 months carrying your child, and you've been in an altercation with them. You never mention that the person is pregnant, the person that you've had the altercation with, which would have been, if nothing else, part of an identifying detail that you could have given the officer since she was no longer on the scene. The second thing is that I keep hearing about this bottle of liquor, but no officer saw the liquor bottle. Also, the alleged victim in this case indicated that she struck the windshield of the car with the bottle. She beat on the door with the bottle. At some point, either the bottle's going to give, is going to be present, or the windshield's going to have indicators. Something's going to happen. No bottle. Miss McKinley left the scene in an Uber, which is consistent with her testimony. She goes to the hospital. The decision to use self-defense is not dependent upon what injuries you suffer, but the apprehension of being put into bodily harm or suffering injury. So even if nothing happened to her, it still would have been proper to use self-defense if you anticipated being harmed in some way. And in this case, Miss McKinley, we weren't able to follow up on whether she had bruises around her neck or whether she arrived at the hospital in only a bra and panties, consistent with being put out in the cold, or any of that, because she wasn't on the scene and there was no follow-up with respect to that. In this case, the court would find that at best it's mutual combat, but I will grant the motion for immunity because of the inconsistencies in the testimony. All right.
Thank you, Judge.
All right, Mr. Lynch, your order to prepare.
Yes, Judge, I'll prepare an order.
All right, so that concludes the 10 a.m. calendar. Thank you for all of you on the 11 a.m. calendar who have waited patiently. I'm going to go ahead and go through that calendar at this time.
Mr. Taylor would indicate that he has an announcement at this time.
Okay, well, let me get to the calendar first because there's other people who have stuff. All right, on the 11 o'clock calendar for September 18th of 2021, one second.
I don't know. He made an announcement.
For the 11 o'clock calendar, the first case on the calendar is Hamilton Bledsoe, Hamilton Christian Bledsoe, and Bledsoe is seeking to revoke the guilty plea.
Withdraw.
I'm sorry?
It appears the defense filed a motion to withdraw the guilty plea.
And
Okay.
the defense would like to present that motion, Your Honor.
I'm sorry. Speak up, Mr. Taylor.
Yes, Your Honor. Mr. Hamilton Bledsoe, he's present in the video courtroom. The defense seeks to withdraw Mr. Bledsoe's no plea to following too closely and to submit a guilty plea to the following too closely. Basically wishes to change his plea from no to guilty. That's his request with no change in the penalty. I believe the penalty has already been substantially complied with.
Okay, so he just wants to change a NOLO to a guilty?
That's correct, Your Honor.
Any objection from the state?
No, Your Honor.
All right, give me the order and I'll sign it.
Yes, Your Honor, I'll prepare that. Additionally, Your Honor, Mr. Bledsoe had a question regarding his probation. He has completed a DUI risk reduction, substance abuse evaluation, attended 10 of 12 recommended classes, attended 10 AA classes, and has made payments and fines. He's wanting to know if the court would terminate his probation upon completion, which he anticipates.
For DUI?
Reckless. It's reckless driving.
No.
Thank you, Your Honor.
All right. Anthony Boston.
Judge, Mr. Boston is present.
And the state is ready.
Defense is ready.
All right, this is on a motion to revoke bond. States ready, defense is ready. We'll have the motion. Hold on. Travion Falante Durham, motion to suppress.
Judge, we're going to withdraw that motion.
Thank you.
All right, motion withdrawn. Anybody on the Durham motion, you're free to go at this time unless you have something pending before the court. Kevin L. McLean, motion to relieve surety. I'm probably already signed that. If not, I will. Okay, so if Mr. McLean is present, this is a motion essentially between your bonding company and the county. It's a civil motion. So if you're here, you are excused at this time. The court routinely signs these when I review my my emails. Okay, so that'll be signed. All right, Jerry Moore, motion to relieve surety, same announcement. If you're here on that motion, it's a civil motion between the county and the bonding company. Court is going to sign that motion, that order. Richard Seth Murray, Kamisha Benz, I saw Ms. Benz on, she's present, and this is a motion to revoke bond brought by the state.
Actually, Your Honor, I'm sorry, go ahead, Ms. Hagan.
Go ahead, Attorney Benz, go ahead.
Oh, no, I was just gonna say, Your Honor, first of all, good morning. We've reached an agreement on both of his cases, so it's gonna be a plea this morning.
All right, so we'll take the plea in a moment. And next is Demetrius Tyrone Ponder. This is a motion to seal. Any objection on the motion to seal on Ponder?
1 second, Your Honor, but you can just hold for my announcement on that one, Your Honor, please.
All right, no problem. If there's no objection, then we'll review it and the court will sign. It's on a theft by shoplifting, so as long as it's restrictable. I'm sorry.
Mr. Ponder's here in the courtroom.
All right, so Mr. Ponder, we're gonna, those are things that are either restrictable and able to be sealed or not, based on what the statute says or based on what the agreement was between the state and the defendant at the time of the plea. So if it is restrictable, I'll go ahead and grant it. If not, we'll give you an order telling you why we could not grant it, okay? But at this time, Mr. Lynch, if you'll get Mr. Ponder's email address so we can make sure that we can get him a copy, and we can go ahead and chat that to Ms. Powell. All right, on Schoolfield, James Kent Schoolfield, he has a pending SSD and a motion to relieve surety. The SSD, Mr. Schoolfield needs to go ahead and pay, or an arrest warrant will issue. The motion to relieve surety, I'll go ahead and sign that in the normal course of my civil orders. So we'll go ahead and relieve anyone on here on Schoolfield because that is a surety motion. Darren DeJuan Washington, that is also a motion to seal. This is on a battery case. I'm not sure we can seal that, Mr. Washington. Is Mr. Washington present?
Yes, I'm here.
All right, you present by video?
Oh, yes, ma'am.
Okay, so Mr. Washington, on a battery case, I believe that the statute says that we cannot seal a battery case. If I'm incorrect, I'm sure the state will let me know, but that is my understanding that it is when it involves violence, it's not something that is sealable. Is that the state's position, Ms. Hagler?
It's my position as well. I can always confirm, but that is my position as well, Your Honor.
Yeah. So yeah, we will confirm that as I review the order, the motion. But the issue that we have is because of the type of case it is, and we'll check back, it was a 2018 case. And so if the statute was different at that time and we can apply the statute that existed at that time, we'll let you know. But essentially that is one where we generally cannot restrict. Okay. Do you have an email address? Because we'll send it to you one way or the other. If I can grant it, I will. If I cannot, I won't, but I will send you an order either way. Did you have an email address?
Yes, ma'am.
Okay, so chat that to Miss Kiera Powell. So when you go to the chat function, click on the name in blue, go all the way down on the list till you see Kiera, starting with a K, K-I-E-R-R-A, Powell, and send her your email address. And then just in a couple of days, check your email. Because I sign electronically, I get things really easily. I don't have to deal with paper. So as soon as I sign them, they go to the clerk's office and they go out to whoever is waiting on a copy.
Okay.
All right. Thank you, Mr. Washington.
All right.
And I see that is on 2 cases, so we'll go ahead and give you orders on both of those.
All right. Thank you.
You're welcome, sir. Winfrey, Marquise Winfrey.
President Court, Judge.
All right, Mr. Winfrey, this is a surety motion. That is a motion, a civil motion between the county and your bonding company. I will sign that motion in the normal course of business. And you're not required to be here. Just make sure that because it looks like something that they're going to that they have the ability to what they call accuse this case. So it still has a TS number, but if they accuse it, you'll get an arraignment date and you'll have to come to court on that arraignment date, okay? You're free to go at this time. And Yasharala, Amaya Yasharala, that case is closed, but there's also a surety motion. We'll go ahead and, if it's appropriate, sign the surety motion to close that out. If there's anyone here on Yasharala, you're free to go at this time.
Your Honor?
Yes.
There's a couple cases from the 10 o'clock calendar, 2 individuals. One is Jackson.
Mr. Cleve Jackson?
Yes, ma'am, Marcus Jackson.
Oh, Marcus Jackson, we on the Marcus Jackson case.
That's Attorney Fry's case.
Mr. Marcus Cleve Jackson. Mr. Jackson, Mr. Fry asked for the motions calendar, and then he's in Henry County. Please get with him and y'all get on the same page about these cases. You keep showing up, which is the only reason I'm not sanctioning you guys, but he needs to be here if he asks for the motion. And so I remember him asking for the motions calendar in court. You need to give him a call and tell him he asked to be put on the calendar. Otherwise, we're not going to be on this calendar until it's a trial. So that motion will be dismissed for want of prosecution.
Your Honor,
yes.
Mr. Fry, I was CC'd on an email from Mr. Fry. I believe he didn't receive notice of today's.
He can refile if he wants to.
Just want to inform the court.
Yeah, I saw the email, but I thought when he asked for the motion, we told him the date.
I don't recall, Your Honor. I just
I know.
So Mr. Jackson also we are still counsel of record on one of his cases.
Okay.
So we just wanted to make sure that Mr. Fry,
did I sign the withdrawal on that case?
We have not withdrawn because Mr. Fry has not. He said he would look into the matter, but I don't know if he's actually.
Okay, I'm gonna have to address Mr. Fry individually because okay, for any lawyer practicing on your own, employ help because you won't miss any money if somebody helps you. In fact, you might make more money. But it gets frustrating when you have one lawyer who has to be in 35 courts at a particular time, and then you can't ever get to them. And so I promise you, you won't miss a dime if you have somebody help you take pleas, answer calendars, things that don't require your primary attention. That's just a public service announcement. All right, so what remains on the calendar are Boston and Murray.
Your Honor,
Murray's going to be up. Yes?
My apologies. There's one more issue. Mr. Baruda, they sent them back upstairs saying that they do need an order signed by you.
Yeah, he's supposed to they're supposed to send the paperwork. I've been waiting for it.
Okay, I'll have him stand by.
Yeah, just have him stand by. And when I sign it, I will tell him and send him back. But I got to sign it electronically because that's the way they're supposed to send it to me. So my understanding was Miss Brenda was supposed to send it. Let me ask, because I've been refreshing my, let me see if she has it.
Is Mr. Jackson clear to go?
Say no because we have a much about bond at 1 and the state is ready.
I'm sorry now, we have what now?
A motion to revoke bond at 1 for
No, Mr. Jackson needs to sit for a minute, because I believe Mr. Fry knew about these cases. And the license. Where- All right. All right. All right. So back to the calendar. Boston is a hearing. Murray is a plea. Are we ready to go forward on Murray?
Yes, Judge. And Your Honor, he actually has 2 cases on the, I believe both of his cases should be on the calendar.
I think so. Yes, ma'am.
We're gonna be doing the plea on the, well, I'll let ASG Hagler.
Yes, Your Honor. So the state is actually going to NAPROS the case number, 2021 CR 06417. I'm going to NAPROS that case.
Zero 6417, you said?
Yes, Your Honor.
All right. All right. So that case, the court will accept the null pros per the negotiations between Attorney Benz and Attorney Hagler. Case 2021 CR 06417, I'm sorry, will be null pros. The remaining case for Mr. Murray is 2022 CR 01184. Mr. Murray, raise your right hand for me.
And Your Honor, before you do that, just to give you a heads up, I did amend the accusation for this case. So the state is going to NAPROS counts 1 through 5 and proceed on count 6. And you should already have the updated version on your end.
I don't, because we print these calendars ahead of time. So what's the number 6?
It was reduced to this disorderly conduct.
State disorderly?
Yes, Your Honor.
Okay. All right, so Mr. Murray.
Yes, ma'am.
Solemnly raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, so Mr. Murray, you can put your hand down. You're before the court. You've heard us discussing your case. So you're before the court on State of Georgia versus Richard Seth Murray. You're represented by Attorney Kamisha Benz, who's with you here on this video calendar. You're entering a plea on case 2022 CR 01184 to the amended accusation that null process counts 1 through 5 and adds the additional charge of disorderly conduct state. Your also your other case 2021 CR 06417 is being null processed. By entering Ms. Benz, what is your client plea to the remaining charge number 6 on the second case?
It should be the negotiated plea was 5.
No,
I'm sorry.
What is the plea meaning, guilty or nolo?
Guilty, I'm sorry.
All right. So Mr. Murray, by entering a plea of guilty to count 6, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, ma'am.
All right, factual basis and recommendation, please.
Yes, Your Honor. On or about February the 7th of 2021, Officer Deason, DEASON, responded to 10 Haver, HAV as in Victor ER Drive, Jonesboro, Clayton County, Georgia. Doing his investigation, it was determined that the defendant physically kicked the door off the hinges during a physical altercation, resulting in a laceration to the victim's head and face area. The victim being Cassandra, Cassandra Thornton, Thornton. Your Honor, at this time, the state's recommendation is going to be a fine of $300 and for the defendant to have no violent or harassing contact with the victim, Cassandra Thornton.
I think I thought the agreement was 5 days credit for time commuted to.
Yes, you're right. I'm sorry. I changed on, yes. 5 days commuted time served. No violent or harassing contact with the victim.
All right, who's Cassandra Thornton, Ms. Benz, to Mr. Murray?
Sorry, Judge, they share a child together.
Oh, Lord. Mr. Murray, you chose to have a child with this woman. You made that choice. And so the person deserves the respect, at least if for no other reason, that's the mother of your child. And the way you treat your child determines the way your child is going to feel about themselves. The way you treat your child's mother determines the way your child's going to feel about themselves. You harm the child's mama, you're going to ruin the child. We clear?
Yes, ma'am.
So if you and Miss Thornton can't get along, go through the courts, legitimize the child, make sure you get all of the things worked out, custody, visitation, child support, all of those things, so that y'all can successfully co-parent a happy, healthy child. Everybody thinks that this stuff works automatically. It doesn't. If y'all just out here willy-nilly having children, but you're not in a relationship with each other where you're dealing with each other consistently day by day with respect and love, then you got to have some rules to this. No child flourishes in an environment where their parents are going back and forth and acting ugly. We clear?
Yes, ma'am.
And as the man in this situation who wants to be a father, not a baby daddy, a father to a child, you got to model for your child what that looks like.
Yes, ma'am.
We clear?
Yes, ma'am.
All right. We got way too many kids being just raised willy-nilly, just in situations where there's confusion, in situations where there's people running around, having relationships and producing children, but not being there consistently to support the child or to support the other parent. And we got to stop this. So
yes,
you need to recognize that you will be, how old is your child?
She's 5.
Oh, and it's a girl too? Because I'm going to tell you right now, you act ugly to her mama, she going to go and find the same person that you are. She's going to go find somebody to act ugly to her. And what I don't want to hear 15 years from now is when you say, nobody going to be mistreating my child. Oh, you mean like you did her mom? Because she's going to look for you. Don't tell me. Women marry their fathers. Women get in relationships with their fathers. Fortunately, I found the man who emulates my stepfather because my stepfather's amazing. But they will find the person because you're their model. So even if it's a situation where she's antagonizing you verbally, walk away. Deal with it later when everybody's cooled down. And the other thing is, make sure you're consistent financially, because if she's the custodial parent, if she doesn't have a consistent idea of how much money she has to rely upon monthly, weekly, daily to take care of your child, not I bought Pampers or I'm going to drop by this or I'm going to drop by that. No, be a consistent financial parent, because the custodial parent doesn't have the right to say, well, I don't have it right now. What would it look like if her mama in that house said, well, I can't do it right now. I don't have a job right now. I don't have the money right now. She can't do that. Your child lives with her. So be consistent financially, emotionally, all of those ways that a child needs to be raised, be consistent.
Okay. I probably, can I say something?
No, not right now.
Ms. Benz is going to, see, I know you want to plead your case.
It is not.
What I'm telling you is,
Richard,
you got to co-parent.
Okay.
And I'm giving you how to successfully co-parent. If you and this lady can't get along, go through the courts, get a written document and follow the written document. We clear?
Yes, ma'am.
Because you got a long time to be in a co-parent relationship with this lady.
Yes, ma'am.
Okay? And well, you know what makes it worse if y'all are not together? When she gets a boyfriend and you get a new girlfriend. That will make it worse. So I'm just telling you, be consistent, get the court to give you written instructions if you can't be consistent.
Yes,
All
ma'am.
right. So 12 months to serve 5 days, credit for time served, no violent or harassing contact.
Thank you, Judge.
All right. Thank you, Ms. Vance.
Nothing further, may I be excused?
Yes, ma'am.
Am I free to
Ms.
go?
Vance, you come. Yes, sir. You come in here, you get it knocked out. Just saying.
But Ms.
Tell
Hagler has been,
some of the other folk who are,
Ms. Hagler's been amazing too. She's been communicating with me. We've been getting it done. So I
That's what
appreciate
I'm saying. If you will commute, if folk will come in and they'll say, "Oh, I'm filing," we plead not guilty, and you never hear from the private attorney again. But if the private attorney is consistent and they talk to Ms. Hagler, we can get some stuff done.
Try to get it done. So I appreciate,
we can get some stuff done.
I appreciate your honor, and I appreciate Ms. Hagler.
Ms. Wright, you had a question. So on the second case, 01184, counts 1 through 5 of the amended complaint, the amended accusation are no pros. Count 6 is what he pled to, which was a guilty. And then on the case 2021 CR 06417, that entire case is for no pros.
But you said 12 months. Is it suspended or probation?
No, 12 months to serve 5 days, balance suspended. I'm sorry.
Thank you.
All right. Thank you.
Yeah, bye-bye.
All right. Are we ready on Boston?
Yes, Your Honor. Let me get the file. And then, Your Honor, before I get that file, I do have an announcement on one of the motions to seal, specifically Ponder. The state is going to agree to that one.
Okay, thank you. So Ponder will be granted.
Yes, and I'm doing some more research on Washington, his 2 cases. So just a few
Yeah,
more
I
minutes.
think those were the 2 that we, were looking at. All right, so we're ready on Boston. Is the defense ready?
Yes, Judge.
And 1 second, y'all. Let me get my file for that one. We can proceed.
All right, so on Boston, this is 2022 CR 01949. Anthony Edward Boston Jr. is before the court on criminal trespass. The state has filed a motion to revoke bond, and Mr. Boston is present and represented by the law firm of Lister, Holt, and Dennis. Mr. Owen Lynch is present on behalf of Mr. Boston, and the state is represented by attorney ASG Jermaine Hagler, and we're ready to go forward at this time.
Yes, Your Honor. Officer. Officer Green, are you on? Okay, 1 second. And before I swear Officer Green in, I would like you to take judicial notice that in the case that's on the calendar, the criminal trespass case, there is an order for bond on the record that was signed by Judge Charity Bridgewater, and that order for bond was signed on May 13th of 2022. And in that bond order, the defendant was to stay away from Cassie Benz and was to also not violate any laws while on bond.
Okay, this court will take judicial notice.
Thank you. Okay. Officer Green, can you please raise your right hand? Okay. Do you swear or affirm that the testimony in this hearing will be the truth, the whole truth, so help you God?
I do.
Thank you. And Officer Green, can you please state your first and last name for the record?
My name is Officer Brandon Green.
And can you please spell your first and last name for the record?
Yeah, first name Brandon, Brandon. Last name Green, Green.
And how are you employed?
I'm currently employed with Clayton County Police Department, assigned to the division, uniform division.
Okay. And how long have you been employed with the Clayton County Police Department?
5 years.
Thank you. And 1 second, Your Honor.
Ms. Hagler, you're muted. Did you intend to be?
Yeah, give me 1 second, Your Honor, please.
Oh, okay. Yeah, that's fine.
Your Honor, at this time, the state is going to withdraw the motion to revoke.
No objection.
All right, so the motion to revoke bond on Boston will be withdrawn at this time. And Mr. Green, I just remind you.
I'm sorry, Your Honor, but I disagree with that. Like, y'all keep allowing this to happen. He violated the conditions of the bond because he came in contact with me and took my child.
Ms. Vance, I want to unmute you, but the problem is when you were in court, I remember telling you that there were certain things that you needed to do that you have not done. If you believe that a crime was committed and he interfered with custody of your child, you need to file a police report and ask for a warrant. Or you can go to the Superior Court if you all have an agreement about custody and visitation.
There is no agreement, and he violated the conditions of the bond. I am suing y'all. I am suing y'all. He has contacted me and threatened me several times, and you keep allowing this man to walk. My son is a part of me. He has no custody in the state of Georgia at all. At all. DFAC emailed y'all and told y'all they did not give him custody of that child. They've been looking for him, and he has not complied in giving an address to where the child even is. Nobody is following the law. And you are the judge that sets the law. I'm a victim, and you are allowing my abuser to keep my child and continue to abuse me emotionally and mentally. It's unfair and it's injustice.
All right. Ms. Benz, courtroom 304. Ms. Hagler, we're going into a breakout room.
Yes, Your Honor.
Ms. Benz, when I send you the invitation to the breakout room, click on it and come into the breakout room.
I'm leaving. I'm going to my attorney's office right now. I have nothing else to say to this court.
Okay, well, Ms. Benz, I've asked you to take the certain steps.
Listen, you asked me to take the certain step, and when I went and did the things that you told me to do, when I went down to the police headquarters, that lady came from behind that desk and said that you said the judge order in the system said that he had custody, that the defense told you he had custody of that child. Then 2 weeks later,
I didn't say anything about custody. I don't know anything about custody, so I know I didn't say that. There's nothing in the computer that says that. All right. Breakout room, Mr. Lynch.
Yes, Your Honor, I'm joining now.
All right, so this is the motion for, to revoke bond on case 2022 CR 01949, Anthony Edward Boston Jr. Mr. Boston currently has a criminal trespass. The parties are ready to go forward. Previously, the state had announced that it was going to withdraw the motion, but after a conversation with all parties, the state has just has decided to proceed. The court has taken judicial notice of May 13, 2022. Magistrate Court Judge Charity Bridgewater issued an order for bond in the case, ordering that Mr. Boston have no contact with the named alleged victim, in this case, Cassie Benz, and also that he not commit any additional offenses. So at this time, the state is ready to go forward. They've called Officer Brandon Green.
Yes.
Officer Green, you've been sworn and you're ready to go forward with testimony at this time. All righty, go ahead, sir.
Thank you, Your Honor. And were you employed with the Clayton County Police Department on November the 29th of 2020?
Yes, ma'am.
Thank you. And are you post-certified and credentialed?
I am.
And are all of your credentials up to date?
Yes, ma'am.
And were you post-certified and credentialed on that date?
Yes, ma'am.
And do you have arrest powers?
Yes, ma'am.
And do you have powers to obtain warrants?
Yes, ma'am.
And did you have the power to obtain a warrant on that day?
Yes, ma'am.
And were you working in your official capacity on that day as well?
Yes, ma'am, I was.
Okay. And were you dispatched to 335 Upper Riverdale Road, Southeast Georgia, 30236?
Yes, I was.
And what was the nature of that call?
I responded to that location at the Chuck E. Cheese establishment in reference to a domestic disturbance.
Do you know what was specifically said regarding the domestic disturbance?
Yes, Miss Benz was having a birthday party for her and Mr. Anthony's child that they share together. I made contact with her. She advised that they got into a argument about Mr. Anthony bringing his girlfriend to the party against her wishes, so they stepped outside, to where she then stated that he started becoming irritated and irate and knocked the birthday cake out her hand, and then proceeded to shove her on the ground where she scraped her elbows before he hopped in the car and drove off.
Okay. And do you see the defendant in this case today?
Yes, ma'am. I believe that's him.
And can you just identify what article of clothing he's wearing?
If I can get the screen to large up. That's the gentleman standing in the courtroom right there behind his attorney.
Okay. And what color is he wearing?
I'll make this screen bigger. It's a collar shirt. It's hard for me to make out the color. It's a light colored collar shirt.
Okay. Your Honor, the record reflects that Officer Green has identified defendant for this motion to revoke bond hearing.
Record shall reflect that.
Thank you. During your investigation, you say you spoke with Miss Cassie Benz. Is she the victim in this case?
Yes, ma'am.
Okay. When you spoke with her, describe her demeanor. How was her demeanor when you spoke with her on that day?
She was upset. She appeared to be in like an emotional distress state. And, she had the bruises and marks on her elbow.
Okay. Did she indicate to you how she received those bruises and marks on her elbow?
Yes, she advised that she received them from Mr. Anthony when they had stepped outside, to where things went from a verbal argument to a physical altercation, where he had shoved her on the ground.
And when you arrived on the scene, was the defendant there?
No, he had already left the scene.
Okay. Were there any other witnesses to the scene that you spoke with on that day?
No. There was no witnesses once, because they had stepped outside away from the party.
Okay. And how did you conclude your investigation?
By determining Mr. Anthony as the primary aggressor, and then I went on to obtain warrants for family violence battery.
Did you obtain any other warrants on that day?
Just the one for the battery.
Okay. Any other warrants besides that one on that day that you obtained for the defendant?
No, I only took out the battery warrant.
Okay. And why did you obtain the warrant for the battery, family violence?
Because of the physical altercation where physical contact was made, and she had received the visible injuries on her elbows.
Okay. And at some point, was the defendant arrested on your warrants? On your warrant? I'm sorry.
Yes, ma'am. I believe at one point he was arrested on the warrant.
Okay. Your Honor, further questions for Officer Green?
Thank you. May I proceed?
Yes.
Officer Green, could you just tell the court the date that you responded to the Chuck E. Cheese?
November 29th of 2020.
Okay. And so you responded and you spoke to Miss Benz, is that correct?
Correct.
And you learned that there was a party going on for her son that she had with my client, Mr. Boston, is that correct?
Correct.
And so you had knowledge that there was at least several people in attendance at that party, correct?
Correct.
And you could have gone into the party and talked to additional witnesses to verify Ms. Benz's claims, is that correct?
There was no witnesses outside to witness the incident.
You didn't speak to anybody at the party. Well, let me ask you this. Did you ask anyone at the party who was there first, my client, Mr. Boston, or Mr. Benz? Did you verify that?
Did I verify what now?
Did you verify who arrived to the party first, my client or Ms. Benz?
I believe she was there first.
And that's just based on what she told you, isn't that correct?
Correct.
You could have verified that by talking to any witness at the party, isn't that correct?
If they wish to talk to me.
In the course, when you're investigating a incident, you have the opportunity to speak to people who are present, and you did not do that in this case, correct?
Yeah, we can't force people to talk to us.
I understand. Ms. Benz told you that the altercation started when she saw Mr. Boston's new girlfriend. Is that correct?
You've asked the what now?
Ms. Benz told you that she was upset because of Mr. Boston's girlfriend being present at the party. Isn't that correct?
Yeah, that's what the verbal argument started at.
Did you speak to the girlfriend?
They were gone.
Okay. You verified the girlfriend was gone?
No, she wasn't involved in the crime.
How do you know?
Because she advised me that it was Mr. Anthony that assaulted her.
So again,
it's them two out there.
So essentially, all the information you have about what happened comes from Ms. Benz, isn't that correct?
Hello? Hey, were you able to make contact? I turned it off. I don't know what happened. Were you able to make contact with the victim?
Hello, whoever's talking. Mute, please. Everybody mute unless I'm talking to you or you're involved in this hearing. Thank you. All right, go back to Officer Green. I'm sorry, Mr. Lynch. Repeat your question.
I don't believe I have any further questions. Everyone on the
Oh my goodness. If I have to say it one more time, I'm gonna remove you from the hearing and you won't be able to get back in. So if you are not the person I am speaking to or involved in this hearing, mute your device. Keep it muted. All right, continue.
Judge, I do not have any further questions for this officer.
All right, any redirect?
Not for Officer Green, Your Honor.
All right, does the state have additional witnesses to present?
Your Honor, at this time, I'd like to call Ms. Cassie Benz please.
All right, Ms. Benz, remember you are testifying in a court of law. Please answer the questions asked, okay?
Ms. Benz, if you can please unmute yourself and turn your camera on. Thank you.
All right, Ms. Benz, sit down. Are you sitting?
I am.
Okay, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. So you're before the court as a witness for the state in this matter. Ms. Hagler has some questions for you. Mr. Lynch will also have some questions for you. And Ms. Hagler, your witness.
Thank you, Your Honor. Ms. Benz, I would like to draw your attention to November 29th of 2020. Do you remember that day?
Yes, it's my son's birthday.
Okay. And please tell the court what happened on that day.
On that day, I had a party for my son at Chuck E. Cheese. Mr. Boston brought the girlfriend to the party who we already had a conversation on not having her around my son because of the dynamic of the situation. The girlfriend was presented as the best friend and they were sleeping around with each other. And then once we separated and the altercation happened, she presented herself as the girlfriend. And it was taunting. It was a taunting situation where they were nitpicking at me, like, hi, I'm here, hi, regardless of what you say. So when we were at the Chuck E. Cheese, I came in with the cake. We were running a little behind, and I came in with the cake, and we were setting the table up, and Mr. Boston's girlfriend had my son in her hands playing basketball.
Okay. And how old was your son turning that day?
2.
Okay. And then what happened next? You said that the defendant's girlfriend had your son in his hands. What happened after that?
I asked Mr. Boston, could we step outside to speak? Everybody left out. We grabbed the cake. Everybody left out the door, and there were no other people there. It was just me and my kids, and Mr. Boston and his girlfriend and her children. And as we were outside speaking, Mr. Boston got upset because of the things that I was saying. And he told me not to step towards him and his girlfriend. The girlfriend started arguing with me. And as I was talking, Mr. Boston knocked the cake out my hand and he shoved me on the ground. And they got in the car, he grabbed my son and they left.
And so when the defendant shoved you to the ground, did you sustain any injuries?
Yes, I scraped my elbows, both of my elbows on the ground.
Okay. And what did you do next?
I called the police.
Okay. And then after you called the police, what did you do next after that?
The manager from Chuck E. Cheese came outside and she was like, I saw the whole situation. She's like, I actually called the police as well.
Objection.
Sustained.
Thank you, Judge. When at some point the police arrived. Okay. And
yes, you have to say yes or no, Ms. Benz, because
yes, when the police arrived on the scene.
Okay. And did you explain to the police officer what happened?
Yes, I explained to the police officers what happened. My daughters also explained to the police officers what took place in front of them. They were crying hysterically. This is not the first incident of him putting his hands on me in front of my kids. A person can say what they want out their mouth. You can't get upset and put your hands on a person because of their words.
And prior to this incident, was there another incident between you and the defendant?
Yes, I had a home in Riverdale. I had a townhome. Mr. Boston was living with me in my home and my 4 children.
I'm gonna check that relevance.
Well, Your Honor, this is relevant as it goes to the motion to revoke bond and the fact that the defendant did violate the order.
Is she referring to the criminal trespass case?
Yes, which happened before this case.
Okay.
All right, go ahead.
Me and my children were home watching TV. Me and Mr. Boston had we were in a disagreement, and I asked him to leave to move out of my home. Mr. Boston came to my home about, I don't know what time it was. It was late. I got a knock on the door. He was banging on my door. He was drunk. I said, no, you're not coming in tonight. You need to come back when you're sober. Mr. Boston got upset because I wouldn't allow him in my home. He bust out my windows in my living room, came through my window, and jumped on me.
I'm going to object again, Judge. She's not referring to the criminal trespass case. She's referring to another case that happened previously. The bond condition.
That's what he got the criminal trespassing charge for, because he came to my property and he did not live there, and he busted out my windows and attacked me.
All right. So
separate case, Judge.
I'm sorry.
She's referring to a completely separate case that Mr. Boston pled nolo contendere to, which is not the case that we're here about today.
Oh, you're talking about the case in
Miss Vance, let the attorneys work this part out, okay?
I'm not understanding what he's saying.
Well, you don't need to, because this is something I need to decide between the attorneys.
She is not.
I need you to be quiet right now.
Judge.
Okay, Mr. Lynch, what's going on now?
Ms. Benz is not referencing the criminal trespass case. As you heard her talking about Mr. Boston jumping on her, that is not alleged in the criminal trespass case that we're here about. She's referring to a prior case that has been disposed, and bond is not relevant to that prior case.
Yes, it is.
That case has
Ms. Benz, stop. Certain things that we're discussing are legal matters. There are matters of law, not what your opinion is. I got to decide those. Now, you have made several statements that I've let you get away with, but I'm done. You have alleged that the DFAX has sent me a letter or called me. I have had no contact with DFAX. And let me just tell you, only time I have anything having to do with children is if a crime has been committed against a child that is a misdemeanor offense. DFAX has not contacted me in this case. I have no knowledge of any relationship or the fact that your child may or may not be with Mr. Boston. I have no knowledge of that. I am not the judge who would receive that information. So when you keep saying that DFAX has told you, DFAX has told me nothing. They've never contacted me. They've never sent me anything. I've never communicated with them. So when I tell you that there are legal matters that you may not understand pertaining to this case, and I'm trying to parse it out and explain as we go, but what I'm telling you is you have an idea about what's going on and how we've wronged you. And I'm telling you, I have no clue about what you're talking about, because I'm not the judge that would even get that contact. Okay. It's not part of this case. Particular things that go on with the status of a child, visitation with a child, custody of a child, all of those belong to the Superior Court, which is on the 4th floor. They have exclusive jurisdiction over certain matters, which means only a Superior Court judge can deal with them, or a magistrate court judge can deal with them if an offense is brought before the magistrate prior to being transferred to Superior Court. That's it. I'm in the middle. So that stuff that you keep telling about, I'm keeping you from your child, or I'm not doing enough, I don't have the ability to do that. That's Superior Court or Magistrate Court. Okay? So when you start talking about what is or isn't happening for the purposes of what I have to decide today, let the attorneys present the information. Let me decide any arguments that may have. And when you're ready to speak again, I'll let you know. Okay? All right. Now, Mr. Lynch, you're saying that this is a different issue than the one where a bond was issued. So if we're talking about a closed case.
She's referencing a closed case. The state alleged in 2022 CR 01949, the case at which the state is trying to revoke the bond for, that my client committed the offense of criminal trespass. There is no reference to any physical contact. There is an allegation that 2 holes were placed in a door at Mr. Boston's residence, not at Miss Benz's residence. She's referring to a totally separate case. And whether or not that's relevant, I just want the court to be clear what.
Okay, what was the date of the case that Miss Benz is referring to, Miss Hagler?
That was going to be my question. Miss Benz, what case are you referring to when you said that he jumped on you? Because I'm not referring to that case. I'm referring to another case. But what was the date?
I'm sorry. So many people keep calling my phone. This was in 2019, and the home we shared was not Mr. Boston's home. That was our home where all our children lived.
Okay.
And Mr. Boston attacked me in that home as well and destroyed my prayer
Hold on.
room.
Okay, so Ms. Benz, so now, Mr. Lynch, what you're saying is that was a case that has since been resolved by a NOLO plea?
Correct. And as far as the 2019 case, I would ask Your Honor not to take that into consideration. First of all, I don't believe that a NOLO plea is supposed to be used in this manner, but either way, it's not relevant to the bond because that case has been closed. He has entered a plea. It's disposed of. Now, what she just referenced, I believe she was starting to allude to the case that bond was issued and that the state is trying to revoke his bond on the criminal trespass case, which allegedly occurred in May of 2020.
All right, so Ms. Benz, can we direct you to the case that you said, Ms. Hagler, it happened at Mr. Boston's home?
No, I did not say that, but you're right, Judge. I do want to direct.
Yeah,
Ms.
please
Benz
direct her to the particular offense that you're talking about. So
Yes,
Ms. Benz, listen very carefully to what she's asking you, because in order for either side to make their case, we have to be very specific about what events we're talking about. Okay, so when she's directing you, listen, don't just say everything that's ever happened, because I'm sure you and Mr. Boston have quite a long history, but there's some specific things that the court has to hear. And so it's better if you listen and answer the question that she asked you specifically, okay?
Yes, ma'am.
All right, thank you. All right, Ms. Hagler.
Yes, ma'am. And so, Ms. Benz, I do want to pick up with you mentioned the prayer room. Talk about that incident that occurred on May 7th of 2020.
Yes, Mr. Boston had been drinking that day. He was really intoxicated. And what we were arguing about, I cannot recall. I was walking up the stairs and I had said something to him that he didn't like. And when I said that, Mr. Boston struck me in the hallway. We started fighting in the hallway. And after we were fighting in the hallway, Mr. Boston proceeded to go downstairs into our den area, into a room that I turned into my prayer room, where I have my prayer area where I pray, and I have certain things in that room. And he went down there and destroyed the room. He flipped over all the bookcases that I had, all my ancestors' pictures. He broke them. He broke the vessels that I received, the way I practice my religion. He broke everything in that room. He destroyed it. When the police got there, he had left.
Was there anything else destroyed in your in the home on that day?
Yes, he put 2 holes in the wall from us physically fighting.
Okay. At some point, did you call the police on that incident?
Yes, I called the police.
Okay. 1 second, Your Honor. And did you record or annotate any of the damages in that incident on that day?
Yes, I have pictures of the damages.
And can you please specify what the pictures are of?
Yes, the pictures of the holes in the wall in the prayer room. The damages to the prayer room.
Thanks, Your Honor, for the question at this time for Ms. Benz.
Cross-examination, Mr. Lynch.
Yes, Judge. So you mentioned, Ms. Benz, you and Mr. Boston's children that you have together. Isn't it true that you only have one child together?
Yes, we have one biological child together, but me and Mr. Boston was together since 2015.
Okay. And the address where this criminal trespass that you just mentioned, that was 8260 Holly Drive in Jonesboro, correct?
Yes, that's on my ID. Mm-hmm.
Okay. And how much was the rent at that location?
Our rent was
objection relevance.
She claimed that she lived at the location.
I'm a resident at that home, and it's a valid. As long as I receive mail there, I'm a resident of that home. I don't have to pay a bill there as long as I receive mail there, sir. That's
Okay. So just to clarify, Mr. Boston paid all the rent and allowed you and your 3 children to live there for free.
no, he did not pay all the rent. Me and Mr. Boston went in on bills together.
Okay. So on the incident where he allegedly put holes in the wall, you said that he jumped on you in that incident?
Yes, sir.
You wrote a sworn statement in that incident in the police report, isn't that correct?
Yes, sir.
And in that sworn statement, you didn't make any mention of him making any physical contact with you whatsoever, isn't that correct?
Can you read the sworn statement, sir?
I sure can. At the date top, it says May 7th, 2020, time 7:42, name Cassie Bria Danae Benz. Starting from the beginning, Anthony Boston Jr. and I got into a verbal disagreement about the children coloring all over the walls while I was in the bathroom doing my hair. The argument led to Anthony Boston Jr. snapping, punching the walls, and destroying my prayer room. He crushed my spiritual tool, which is called an egun pot, as well as my altar I built for my ancestors, being very violent in front of my kids. I called 911 and he fled the scene. Why is there no mention of physical contact?
Because when Mr. Boston came up the hallway, I was in the restroom doing my hair. He got upset because our son that we shared together, and at the time, my 3-year-old daughter, they were coloring and they colored on the wall. So he got upset and started snapping and talking to the kids crazy. And I told him not to speak to the children like that. And when I said what I said to him, he got upset and he mushed me into the wall. That's how the door hit the wall and put the hole in the door, in the wall.
Why didn't you include that in your statement?
I did. And that's, if you have the officer, they had it recorded. You can pull the recording up, the video from the officer's camera.
Yeah, you are aware that the officer does have a body cam recording, right?
Mm-hmm.
Okay.
No, you have to say yes or no, Ms. Smith.
I am aware.
Now, I want to move on to the 2020, November 29th, 2020 allegation that you mentioned that happened at the Chuck E. Cheese. Isn't it true that you found out that this party was going on while the party was already going on? And
no, sir.
Boston was already there. Isn't that true?
That is not true.
You said you arrived late to the party in your earlier testimony.
I set up the party and asked him to bring my child, to drop my child off at his party. He brought the girlfriend and her 3 children who were not allowed to be around me because she kept telling him my child was autistic and my son is not autistic. She don't even want my son at his house, at her house. My son can't even go to her house when he's there.
Miss Benz, you're not answering the questions he's asking you.
I'm just saying he's trying.
Not just saying. I need to know specifically.
I set the party. I set the party up.
Okay. Did you pay for the party?
I paid for my children to play. I put money on their cards for them to play at the Chuck E. Cheese.
Okay. Who called and said, "Hey, can I reserve a party room?" Is that the way it works at Chuck E. Cheese, or do you just go?
You could just go, and if they have a table available, you can, grab the table, order the pizza, set a little table up if you want to, or you can do a birthday party package where they set a big table and an area up for you. Unfortunately, at that time, I could not afford that.
Okay, so you all just were gonna go there and celebrate once you got there.
Yes, ma'am.
Okay. All right, go ahead, Mr. Lynch.
So, Ms. Benz, when you arrived, Mr. Boston was already present at the Chuck E. Cheese, isn't that correct?
Yes, Mr. Boston was there.
Mr. Boston was there. And you knew that he was there, correct?
No.
You said you were upset because he was there with the girlfriend that you didn't know. So you...
No, we know her, but we knew her as the best friend. Mm-hmm. They were sleeping together behind my back in my home.
So it's your testimony today that you didn't know that Mr. Boston was at the party at the Chuck E. Cheese's?
I didn't know the girlfriend or him was there when I arrived. No.
You didn't.
You knew he was coming.
Yes.
And he was expected to bring your child.
The child was expected to be dropped off. Not him, not the girlfriend, just the child.
Okay, but when he came, when was the first time you knew that he was there and that the girlfriend were there?
When I came in, I set my table up, and when I turned, Mr. Boston and the girlfriend was already in the corner with my son.
Okay.
But my son was supposed to be dropped off to me.
Okay, so when you said he was supposed to be dropped off to you, were you supposed to get there? Mr. Boston was gonna call you and then bring your son to you?
Yes, so when I got there, someone was supposed to bring Amir to the location, to the
And
party.
when you say someone, who was that?
Either his mom, his sister, because we weren't supposed to be in contact with each other.
Okay, so did his mom come to the party?
Nobody came, no.
So it was just Mr. Boston and the girlfriend.
Yes.
And her children.
Yes.
And at the time you said y'all weren't supposed to be in contact. Were you aware that there was a no contact provision?
I was not aware of the no contact provision. I was just aware that from the previous situation that, me and him, we don't do good with trying to figure things out between each other. And for my safety, the kid's safety, and his safety, let's just try to find somebody else to communicate through.
All right. And these arrangements, did you make them by phone or text message?
By phone.
Okay. So you had spoken to Mr. Boston.
Mm-hmm.
Yes or no?
Yes. I'm sorry.
Okay. So you spoke to Mr. Boston and y'all agreed that your son would arrive at the party.
Yes.
What time was your son supposed to arrive at the party?
I can't remember exactly what time. I can't recall the time.
Okay, was it day? Was it evening?
It was in the it was probably about 3 o'clock. I'm gonna say about probably 2-3 o'clock in the afternoon.
Okay. And how many people were you expecting at this party?
My sister, two of my sisters. My sister was gonna bring her stepkids, her 3 stepkids, and I had a friend that was coming with her daughter as well.
And had they arrived by the time that Mr. Boston was there?
No, when I arrived, I had texted everybody, told them I was there, and everybody was en route. We wasn't even there 5 minutes before I asked him, can we step outside and talk? And the girlfriend came outside too to talk too. And that's when the situation escalated.
All right, Mr. Lynch, continue.
So it's your testimony that your sisters talked to the police. You testified to that, correct?
No.
Oh, you didn't?
We didn't say anything about the sister talk to the police. The police just told you.
The testimony was that she talked to the police and a minor child talked to the police, her daughter.
You called 911 on at least 2 occasions. Isn't this correct? Didn't you call 911 on at least 2 occasions?
I'm not understanding what you're asking.
Did you call 911 to report your allegations that happened at the Chuck E. Cheese's?
Yes, I called 911.
And isn't it true that at the time you called 911, you were following Mr. Boston's car in your car?
No, sir.
So if the 911 recording does not have the 911 operator telling you not to follow Mr. Boston, that's your testimony?
I don't recall that, sir. And if I did, it was because your court system has failed several times to protect me and my children from him assaulting me. So I wanted to make sure that they had a tag number or something to be able to serve Mr. Boston so that I can receive justice for a person not knowing how to control his anger and have self-control over himself. I can say whatever out my mouth. I can say whatever out my mouth.
All right,
if I don't put my hands on you, don't put your hands on me.
Ms. Benz, you're being non-responsive, which means that you're not answering the question.
I just answered his question.
Yeah, but then you went into this rant about people putting their hands on you. He asked you whether you followed the car or not. All right. Mr. Lynch, continue.
So at first you said you didn't follow the car, you didn't remember, but now you're explaining that you followed the car to try to get a tag number. Why did you make a false statement to the court just prior to the first question?
I said, sorry, you know, this case happened in 2020. It's 2024, 4 years down the line. My knowledge of each detail of how the situation and what happened and took place there, sir, is fuzzy. Okay.
And let me ask you this. You mentioned controlling anger. Do you ever have any issues controlling your anger?
No, I haven't.
Okay. Excuse me. Isn't it true that you tried to attack Mr. Boston's girlfriend at this Chuck E. Cheese?
Objection relevant.
Okay. I'll move
You
on.
can pull the security camera and you can see everything.
Okay.
All right.
I don't have anything further at this time for Ms. Benz.
All right. Anything else from the state?
No, Your Honor.
Okay. All right.
May I? Excuse me.
Yes, sir.
Oh, I didn't mean to interrupt, Judge. I was just waiting for a chance to make some argument.
Okay. Does the state have any additional witnesses to present?
No, at this time the state rests.
All right. Does the defense have witnesses or evidence to present on behalf of Mr. Boston?
No, Judge, we're not going to present any evidence today.
Okay. All right. Sorry. All right. All right. Let me hear argument.
Judge, may I proceed?
You may.
So first of all, and Ms. Hagler can correct me if I'm wrong, but I believe she indicated that the bond order was issued in 2022. This alleged incident happened in 2020. So he can't violate a bond that has not been set. So that's the first part of the argument. And I would, if I got that wrong, I would ask Ms. Hagler to correct.
I will make my argument when it's time for me to make my argument. Sure. Thank you.
Secondly, Judge, Mr. Boston has announced ready for trial on both the alleged incident, the criminal trespass, and on the battery case. And he strongly contests the allegations of Ms. Benz. I would have him testify today, but in order to do that, we would have to let our trial strategy go. We would also have to have him give up his right against self-incrimination. And we don't feel that that's necessary at point. However, Judge, from the testimony of Ms. Benz, it's pretty apparent that she voluntarily had contact with Mr. Boston at the Chuck E. Cheese's, number one. Number two, it's our position that, well, so it's our position he did not violate any bond by having contact with Ms. Benz because Ms. Benz came to where he was. We're going to contest and we're going to present evidence at the trial that that she found out about the Chuck E. Cheese on the day.
Okay, but if that's evidence you're not willing to present here, you can't argue it here.
Exactly.
Sure, Judge. So I would also like to point out that Mr. Boston announced ready for the criminal trespass case, which there's no allegation of any physical contact, not in the statement that was given to police. And now, inconsistent with that, Ms. Benz says that there have been multiple inconsistencies in her testimony, and Your Honor can use that to determine her credibility. Ultimately, a jury is the most appropriate fact finder to determine what happened in this case. I would like to point out that this motion to revoke bond was filed September 4th, 2020, the very same day when the state found out, or that when I announced to the state that we would not be entering pleas to either of these cases because we contest the allegations.
You mean 2024?
sorry, 2024. So
Okay.
a full approximately 4 years after the alleged bond violation. Mr. Boston has been in court for every appearance. Mr. Boston is not running away from these charges. Mr. Boston looks forward to his day in court where a jury can evaluate the credibility of the claims with regard to the criminal trespass case and with regard to the allegation of battery family violence. Mr. Boston works full-time as an electrician. Mr. Boston does not have an extensive criminal history. So Judge, even if you were to find that there had been a bond violation, we only locking Mr. Boston up pre-trial is not the only action the court can take. So number one, we would argue that that has not been proven by a preponderance of the evidence. But number two, even if you believe that it has been, we would ask that you allow Mr. Boston to have his day in court. There would be no bond to violate if I had not gotten sick on the court date for the criminal trespass case. And I would ask you not to hold that against Mr. Boston either. He is aware of the bond conditions. He is not violating the bond conditions. He is willing to abide by any additional stipulations the court were to suggest in this case. But overall, Judge, based on what has been presented to this court, it has not been established that he violated his bond conditions. And again, even if it has, Judge, we would ask that you wait until he has his day in court. And then if he's convicted, then Your Honor obviously will have the ability to sentence him under the law.
Okay. All right, Ms. Haylor.
Thank you, Judge. The state would ask that you do revoke the defendant's bond until his trial. For clarity purposes, the order for bond that I did read out, yes, it was signed on May 13th of 2022, but on the bond order, it does have the criminal trespass damage to property case on there, warrant number 2020 CW 52107. And it also has the battery case that we're here today on as well. Again, the warrant number is 2020 CWC 1250. So both cases, the one that's currently on the calendar and the case that he's being revoked for, are on this one bond order. Based on the testimony that we heard, we did hear from Officer Green, who did testify that on November 9th of 2020, he did respond to the incident location regarding battery family violence. He did indicate that he did see visible injuries on the, he did indicate that he did see visible injuries on the defendant while at the Chuck E. Cheese. He did determine the defendant to be the primary aggressor. We also heard from Ms. Benz herself, who gave the same testimony that, the defendant did push her on that day while at Chuck E. Cheese and that she did sustain visible injuries. We also heard that there was a previous incident that again occurred on May 7th of 2020 in which the defendant did destroy her spiritual, her prayer room, her igun. He did put holes in the walls. And so, Your Honor, again, the order did say that he is to stay away from the from the victim, Ms. Cassie Benz, and to not violate any laws. The reason why this motion to revoke was not filed early is because I wasn't here 1, 2, 3 years ago. I got here in July of this year. So that is why it is just not being brought to the court's attention now. And so for those reasons, testimony of Ms. Benz and testimony of Officer Green, we would ask that you revoke the defendant's bond until trial. Thank you.
Okay, so let me ask a clarifying question, Ms. Hagler. So you said that, so this is how I know magistrate to work, but it's been, I think I haven't been on magistrate court in 9 years, almost 10 years. Things may have changed. But generally, when a warrant is issued, if the person is arrested pursuant to that warrant, and a CW would mean that somebody, an officer came into the office, asked the magistrate to hear sworn testimony, the magistrate then types up the warrant, and at that point, the officer can proceed on that warrant. It is not one where the officer was present at the time the offense happened, which would have been a CAA, which would have been a warrantless, I mean, a WAA, or warrantless arrest affidavit. It would have been after some investigation or after going to the scene, the officer collects information and then they go to a magistrate, ask that magistrate to produce a warrant, and then that warrant is then entered into the system and the person is wanted. My understanding from what you're telling me is that he was not initially arrested on the 2020 CW warrant. That warrant was still showing wanted when he was then subsequently arrested on the next case. And for both those cases, the bond condition was set to require that he have no contact with Ms. Benz. Is that correct?
Yes, no contact, and then not to violate any laws.
So when Mr. Lynch is testifying that for the 2020 CW, which would have been first in time, he did not have a bond condition until he was arrested on that and the subsequent event. So two events were committed. He wasn't arrested on the first one. When they arrested him on the second one, they processed both the CW and either another CW or a WAA. So one of them was in 2020, the other one was in, I think you said 2021 or 2020.
Both were in 2020. One occurred May 7th. The criminal trespass occurred May 7th of 2020. And then the battery family violence occurred November 29th of 2020.
But he wasn't arrested on any of them until 2022.
That based on this bond order, that's when it was signed.
Okay, so that's what that would have meant, that he was wanted for both of those things for almost 2 years. And when he was finally arrested on those two offenses, the court then had a first appearance hearing where he was given notice that he was not to have contact with a particular person, Ms. Benz, or go to a particular location possibly.
That's what appears from this warrant, from this order for bond, sorry.
Okay, so, and this is where Ms. Benz is about to lose it, but Ms. Benz, let me explain to you what happened. So he had warrants that were out there, but he wasn't arrested. He wasn't arrested until later, and when he was arrested, then at that time, he was given notice of the bond conditions. I can't hold him responsible for bond conditions that weren't even in place at the time, or he didn't have knowledge of at the time. And so even though both of those events took place one after the other, had he been arrested on the first event and given a first appearance and been told that he had bond conditions, then I would be able to hold him accountable because he is knowledgeable that these bond conditions exist and you're not to have any other offenses and you're not to have contact with this particular person. Number one.
That case y'all won't allow us to talk about in the courtroom. They told him.
Ms. Benz, it doesn't matter whether you're allowed to talk about it or not. What I'm saying is the state of the bond conditions is until a bond condition is served upon the person and they're given notice that this is what you cannot do until that hearing is held, then they're not responsible for that. So he had two outstanding warrants. The first warrant, he was never arrested on until the second warrant happened. When he came to Chuck E. Cheese, then they were able to arrest him on that second warrant, the Chuck E. Cheese incident, and the first warrant, which was outstanding. And at that time, he was given bond conditions. Now, if he committed a crime after that, after the date that he was given the bond conditions, which was May 13th of 2022, if there is a crime that occurred after May 13th of 2022 that he was arrested for, then I could hold him on a bond revocation. But because he was not given bond conditions until the date in question, and that predated, those two offenses predated his bond conditions, I cannot hold him responsible for having violated the bond conditions. That's number one. And number two, even though there were no bond conditions in place at the time that you all agreed to meet at the Chuck E. Cheese, you admit that you agreed to have contact with him. What set it off was Mr.
I didn't admit to
Boston,
anything.
Miss Benz. Let me finish. What you admitted that you agreed to have contact with Mr. Boston. What set it off was under your testimony is that he arrived with his girlfriend and her children who were not expected to be there. And Miss Vance,
courtroom,
which he arrived with his girlfriend and her children, and they were not expected to be there. So at that point, that's what set off the encounter. But at that point, Mr. Benz was not under a bond condition from this court that this court can rely upon to hold him responsible. So with that being said and all laid out, Mr. Ben, I cannot revoke a bond condition, a bond for revocation where the condition was not in place at the time that the offense happened. So that's where that stands. And thank goodness for my knowledge as a magistrate court judge, because you got to walk this down slowly. Now, other things I want to say about this case. Ms. Benz, you are hot mad about what's going on in this situation, but you seem to be really, really
because you allow my abuser
Ms. Benz,
to my son.
you seem to be really, really focused on the girlfriend. And I understand that she's an irritation and an issue.
About the girlfriend, I'm focused on the safety of my son. They leave him home by himself. He's called me on his.
But I want to clarify certain things. One, I've never had any contact with DFACS about this case or about the minor child.
Last time in the court,
I don't know anything about the minor child in this case or his situation or his whereabouts. 3, if it is an issue where the minor child is endangered, then that is an issue for the police to handle under whatever offense is appropriate at the time. I have not directed Ms. Benz to do anything but to speak with the victim witness advocate in the Solicitor General's office and to seek possibly a temporary protective order. I have not directed the magistrate court to do anything. I've not directed any other body to do anything in this case because I don't have that ability. So I am not in charge of the safety, welfare, or have any knowledge about where this child is. I don't have any knowledge about what the legal status of the child is, whether Mr. Boston has any right to have the child or whether he has been granted a temporary guardianship or conservative, anything. I don't have any of that because that is not before me. Okay. If there is something going on with this child, then the child, that needs to be handled through the police or superior court, the superior court of the county where the child has resided. So if it's not handled by superior court, if it's not handled by the police, it is not something that is currently before me. I can't make Mr. Boston return a child because I don't have that power. And so just to be clear, Ms. Benz, I don't have the power to do what you're asking me to do. A superior court judge might, or the police might be able to arrest, but none of what has been said here and none of the cases in front of me involve a minor child. And so I'm putting that on the record. You can sue all you want to, you can rant, rave all you want to, but none of that involves this court. State court does not have jurisdiction over those matters. None of what has been alleged has anything to do with a minor child being involved. And therefore, I'm clarifying for the record that the allegations you made against this court can't be supported. And so if you want to pursue the custody of the child, then like I said, you need to go through superior court or you need to go through the police and have them file a warrant for whatever they deem is appropriate, but it cannot come through me because I don't have that power. So everything that all the power that you've given me, I don't have. Okay. So with that being said, at this time, the motion to revoke is denied. The court has put on the record all of the information that it has regarding this case and the situation that exists. And at this time, Mr. Benz, I will remind you that you are currently under a bond condition that says that you're not to have any contact with Miss Benz, that you're not to go around her, that you're not to have a third party contact her. And let me be clear, I hate cases where people bring in the girlfriend. The girlfriend did not have a child with Miss Benz, and so she has no right to have any connection with Miss Benz. She didn't lay down with Miss Benz. She can't get up with Miss Benz. And so when you bring the girlfriend in as a surrogate to participate in an argument with Miss Benz or to talk to Miss Benz in any way about Miss Benz's child, that's inappropriate. You're the person who had a child with her. You need to have those conversations. Don't bring your other party around, especially when you know it's gonna be a problem. That's irresponsible. So let's start thinking about mature co-parenting as opposed to all of this high school stuff where I'm gonna bring my girlfriend and she gonna fight you and all that foolishness. It really is ignorant. So Ms. Benz, I've clarified my position in this. I've made my statement. I have reminded Mr. Boston that should you violate the conditions, you could be arrested until this case is resolved. You could also be charged with additional misdemeanors or felonies punishable by up to 10 years in prison, a $10,000 fine, or both per offense. And so at this time, the motion is denied, but the Solicitor General's office, per any information that they receive, could bring that motion to revoke back. And let me be very clear, it could be based on a third party contacting Miss Benz, namely a girlfriend or some other family member or person acting on your behalf. So please tell them that they don't help you in any way by doing that. Okay, even if they're using an anonymous number, technology is such that things can be traced. Don't make them find it. All right, so that concludes this case. All righty.
Serve him without an address for you to even for me to even do the things you're telling me to do.
Miss Benz, I can't ask him for his address. I can't compel him to give me that.
Forward to get my son to even do the legal things that you're telling me to do.
Miss
How
Benz,
am I supposed to do this? What I'm saying?
Miss Benz, let me just tell you something. Miss Benz, if you will listen to me, let me tell you something. My mom she practices law in South Carolina, and this was a point she made to someone once. You have a child with somebody, you choose that person. If you got a child with somebody and you don't know their address, how do you think I'm going to figure it out? I don't know him. I don't know where he's lived. I don't know his people. I don't know who he is. You have way more information than I do. I can't compel him to give me his information, and I didn't have a child with him. So that's what I say. When we're having kids with folk that we barely know. Folk are just having kids with people that they barely know. They're having kids with people that they wouldn't even marry, but they're having kids with them. And then you expect the courts to enforce a relationship that you don't even have.
Judge,
so I'm not going to take that abuse because she failed to have a child with the right person or to get the right information. I'm not doing that. Y'all need to be more careful about who you procreate with. I'm serious about that. Children being brought into this world in the midst of foolishness, and the foolishness just continues. And the only people who suffer are the kids. So Ms. Benz can have whatever tantrum she wishes to have, but I have made my ruling and I have put it on the record. All right. So next, 1 o'clock calendar.
Your Honor, before you move to the 1 o'clock, I do have an announcement for the motion to seal for Washington for these two cases, whenever you're ready.
Okay, I'm ready.
The first case, after review, the state doesn't have any issue with that one to seal. However, the second case, the state will ask that you deny that motion.
All right, so in Washington, Ms. Powell, the motion will be granted as to the first case. The second case involving the battery, is that correct?
Yes, Your Honor, because that'll be denied.
The second case will be denied. All right, Ms. Powell, did you need anything else?
I don't think so. First case approved, second case battery is denied.
All right, thank you, ma'am.
Excuse me, Judge.
Yes.
It's Sergeant Williams.
Yes, Sergeant.
I was here for Parks Dion. I need to know if I'm still needed.
Yes, ma'am, because I haven't even done the 1 o'clock calendar, and I'm assuming that since it's not ringing a bell, that's the 1 o'clock. I'm gonna call that right now. Hold on a second. Miss Brenda, I'm trying to sign this order that you sent me because I know they're waiting. Let's see. But I put my phone number on here for DDS. Okay, so I'm sending it back. If you need to add my name printed, you can go ahead and do that, Miss Brenda. I can't figure out how to make it work with my keyboard not acting right. All right, so on the 1 o'clock calendar, all right, so on the motions calendar for 1 p.m., the first case on the calendar is Tavion Richard Armstrong. That's a surety motion. Mr. Armstrong, if anyone's present on that case, the court is that's a civil motion between the county and the bonding company, and the court will sign that motion once it is presented. But Mr. Armstrong's case has been closed, and the court will go ahead and sign as needed, okay? The next case is Mickey Blount, Mr. Mickey Blount. That's a motion, a surety motion also. So the court will sign that as a part of the civil motions that are presented. The next case is Tamika Latasha Cook. That is also a surety motion. That also will be signed. All right, Chris Julius Irvin Jr. Mr. Irvin's an active inmate. That is a motion to revoke bond. Are we ready to go forward with Mr. Irvin's case?
Yes, Your Honor. I just need to confirm that Officer Gant is. Oh, yep. He's. We're ready. We're ready.
All right, Mr. Taylor.
Your Honor, our firm hasn't been appointed to Mr. Irvin's case. We haven't spoken to him about this. He's currently in custody. I did check on felonies. His $300,000 bond on his outstanding felonies as an active inmate. If the state wishes to go forward with this bond revocation, we just ask for the motion to be continued to another calendar so we can submit our appointment order and meet with Mr. Irvin.
Why did not I remember him coming out? Did I not appoint you, or did he? Was this one of those ones where he said that his family had gotten counsel for him?
Your Honor, I do not recall that particular calendar, but
it was an in-court calendar on the criminal. It was the criminal calendar call last Monday, and it was in court. And I remember him coming out, and I remember you all saying that he was being held on felonies and would likely not be out of jail. But the motion remained, and I talked to him about counsel, and I didn't know if we were doing conflict check, but beyond that, I don't remember I don't have my notes from that calendar. So I can appoint if he's willing to have you all, if y'all check and see if he wants you all as counsel, I can appoint. Otherwise, I'm going to appoint someone from the conflict counsel list to assist him. And I will move the motion since I guess I never clarified who was going to be working on his behalf.
Well, Your Honor, according to Ms. Arnold, she said that you did appoint them, I guess, at the last hearing, and Ms. Arnold can.
Yeah, that's what I thought I did. That I had
clarity. Mm-hmm.
Yeah, during the trial calendar.
Yeah, the calendar call. I remember bringing him out, him standing in front. Now, I did remember that and asking y'all for an order, but based on the fact that he is in on a pretty hefty bond on the felony charges, we can move him to a calendar next Tuesday.
Yes, Your Honor.
All right, so Ms. Val, let's put him on the Tuesday arraignment calendar and we'll hear that motion to revoke. And then that way, once that's clarified, or he may decide to take a plea, I don't know. But if that's clarified, then he will be clear on what needs to happen upstairs. Okay. So Marcus Cleve Jackson, this is the one, Mr.
Judge, I'm sorry to interrupt, but which defendant was that so I can make note for Miss Val?
Irvin.
Okay.
Ervin. Oh, I'm sorry. That's right. She's out today. Thank you. So with Mr. Jackson, I remember Mr. Fry asking to be put on a motions calendar for the motion to suppress on his case. And I thought I told him the date of the calendar when he came into court, which was also on that same open calendar date. But he hasn't appeared. But the other case with Mr. Holton Dennis was sort of in an up situation because the state have asked that he be removed, that Mr. Holton Dennis as indigent counsel be removed from Mr. Jackson. And Mr. Fry has not taken on Mr. Jackson's case for simple battery, family violence.
Your Honor, would you like for me to call Mr. Jackson to the camera to explain?
Yeah, I mean, you might as well. All right, so Mr. Jackson, since the 10 a.m. or 11 a.m. calendar, have you spoken to Mr. Fry?
No, ma'am. And yeah, I spoke with him before I came and he said, I didn't get a notice either for this court date, ma'am.
Yeah, but you were in court when I announced it.
No, you actually told me in October.
Did I say October?
I was just here last week.
I know. All right, so we'll move Jackson's cases to the October calendar.
Is that both of them, Judge? Because the
Both
state
of
is
them.
ready for the motion.
Both of them. Mr. Jackson, Mr. Fry, Mr. Fry needs to come on to this case, or you need to get another attorney.
Well, ma'am, like I said,
I know what you've said, but the problem is you hired counsel on one of your cases and you have indigent counsel on the other. The problem is if you can hire counsel like Mr. Fry, then that indicates that you're not indigent.
Well,
and the state is, okay, we can have a hearing on whether you are indigent. I'm willing to do that.
Yes, ma'am. That would work for me.
All right. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right. So, Mr. Jackson, you don't have to tell me anything you've talked about with your attorneys. You don't have to tell me that anything that they've shared with you about either of these cases. But please tell me how you were able to, who hired Mr. Fry on your behalf if you didn't?
My family did, ma'am.
Okay, who specifically?
And it was actually put on a credit card. So, and I'm actually
put it on a credit card.
Yes, I'm paying the bill. So it's
who put it on a credit card?
Excuse me?
Who put it on a credit card?
A friend of mine.
All right, and you're paying the bill?
Yes, ma'am.
All right, so then, Mr. Jackson, that indicates that you have the ability to pay an attorney, whether you put it on a credit card or whether you paid them in cash up front.
No, I don't, ma'am. That was a one-shot deal, actually. And that was the cost of it. I can't afford another.
Okay, how much do you make per month, sir?
Like $3 grand.
What you do?
I'm a carpenter, ma'am.
You're a carpenter?
Yes.
So you can make $3 grand on one job. Please don't play me because my family's in building trades and we own property. So don't do it. And my grandfather was a carpenter. I got family members who are builders. That's not even materials cost. $3,000 ain't even materials cost. And once you get into labor, you can make $3,000 on a job and you're doing more than one job in a month. So sir, don't come here and lie to me.
Ma'am, I don't work for myself. I work for a company. This is the company that I work for. I'm not self-employed, ma'am.
Mm-hmm. Do you have any pay stubs with you?
No, I usually don't carry pay stubs with me.
Do you get direct deposit?
Yes, I do.
Can you go on your banking account right now and open it up and show where the direct deposit was made?
Yeah, I can.
All right, do that.
And I just want to note for the record as well, ma'am, I'm having surgery on my shoulder.
Okay, no, I'm still on the direct deposit. It's not about whether your shoulder hurts. I
Well,
need to know whether you can afford the attorney.
It is because I'm going to be out of work for a substantial amount of time because it's on my rotator's cuff.
Okay, but you're not out of work now. You're paying for Mr. Fry.
Ma'am, I can't afford to. I can't afford.
Well, Mr. Jackson, then the best thing is not to get arrested for two things. I'm trying to do this the right way. If they're asking that we verify whether you are entitled to indigent defense, I'm willing to do that. But I'm just telling you, I didn't ask you for all that. I asked you to tell me how much you make per month.
Ma'am, I don't get any signal. I mean, the officer can come in here and see. I don't get a signal in here at all. It's just rotating. I can show you that. It's just rotating.
You playing with me, Mr. Jackson?
Ma'am, you want me to step outside and do it? I'm not. I'm showing you. I can show the officer I'm not getting a signal in it. Believe you me, ma'am, I'm not trying to upset you, Your Honor. I'm doing what you asked me to do, and I'm not getting a signal. And if you can see that, it says, please try again. I'm not trying to upset you, Your Honor.
How much you pay for rent or mortgage, Mr. Jackson?
$1,650. And I do have a daughter living with me that's schizophrenic and bipolar.
Okay, you keep telling me stuff I'm not asking you. Do you rent or own?
I'm renting. Well, I'm just trying to give you the whole picture, ma'am.
No, I'm gonna ask you for the whole picture when I'm ready for it. I'm asking you right now. You claim you make $3,000 a month. Does anyone live with you?
My daughter, ma'am.
Anybody else?
No.
How much do you pay for your car?
$850.
That's for what?
My car payment.
What kind of car are you driving? Oh, there it is. A Mercedes what?
No, I didn't say no Mercedes.
What did you say?
A Cadillac, ma'am.
Okay, yeah. You're paying $850 a month and that's the car note, not the insurance. What you pay for insurance?
Like $3 something.
Okay, yes, sir. You can afford counsel. You have until October to hire counsel for your second case. You got gold around your neck. That's sell it.
Your Honor, can I just ask you one?
I know the price of gold. Sell it.
Can I just ask you one question?
No, Mr. Jackson, I don't want you to jeopardize your case at all. But I'm sick of playing with you, and these cases need to move. So you got Mr. Fry for one case, hire somebody for the other case. But we're gonna move these cases. When you come back in October, you either gonna argue your own case or you're gonna have an attorney. Okay, that's fine. You're entitled to that.
I'll argue my own case.
You're entitled to that.
Yes, ma'am. But I'm just wondering, after 4 years, now it's just been brought to my attention that I have to have another attorney. But I've been coming.
Mr. Jackson, your case didn't come before me until it did. And when it came before me, the first time it came before me, Ms. Hagler brought it up.
Ma'am, I've been seeing you for 3 years, and this is the first time it's been brought up.
Well,
I was dealing with the other guy that doesn't work for them anymore.
You're entitled to ask. Most time they don't care.
Yeah,
but for some reason they care about yours. So, all right, Mr. Jackson, we'll have you on another calendar in October. Thank you. You're free to go at this time. James Jamar Johnson, that case has been closed, and that was on a motion to revoke. So that motion is no longer necessary. On the Tommy Lee Johnson, that case is a surety motion. I'll go ahead and sign that as necessary. And the case is closed. Jaquan Demetrius Jones, that case is closed. That is also on a surety motion. That will be granted for the surety motion. Dion Hector Parks, that is a motion to revoke bond.
Your Honor, I believe that's a similar situation to Mr. Irvin. We may have been appointed at the calendar call.
You were.
Okay. Mr. Lynch is speaking to him now.
All right. Tell me what you come up with. Ernest James Stoudemire. That is a surety motion that'll be signed, or has been signed, in the, for the civil cases. Deja Deneen Wilkes, that is also a surety motion. Ladies and gentlemen, if I say it is a surety motion, and I'm going to go ahead and grant it, a surety motion, that is between the bonding company and the county, and they have made an agreement as to something having to do with the bond. So if your case is the underlying case, you're not required to be here for that, although you do get notice of it, and you're not required to participate in any way. So if there's anyone here on these cases that I've said are surety motions, then you are free to go at this time. That will be between the county and the attorney representing the bonding company. So that would be Armstrong, Blunt or Blount, Cook, Johnson, Tommy Lee Johnson, Jones, Stoudemire, Wilkes, and Wright. So anyone here on those cases, you're free to go at this time. Your bonding company should have let you know that it is a bonding company motion, but you're free to go at this time. Remaining cases are Parks and Jackson is going to be continued. So I have Parks remaining, and is there another one?
You continued Urban, correct, Your Honor?
I did.
Okay, thank you.
To the Tuesday calendar.
Tuesday calendar. Your Honor, on earlier calendars, in the matter of Mr. Cooper, we would like to enter a plea today.
Okay.
All
right. So Mr. Lynch is talking to Parks. Is that correct?
That's correct.
All right. Ms. Hagler, we're about to take a plea in Cooper. Otherwise, release all witnesses who are not necessary, with the exception of those here for Parks, and that way we can get some people back to their lives.
Thank you, Judge. Yes, all officers who are still present, if you're not on the Dion Parks case, you are free to leave. Again, if you're not on the Dion Parks case, you are free to leave. And thank you for your support and patience.
Your Honor.
All right. Yes, sir.
One last thing, my apologies. Mr. Beretta, did you ever get that paperwork for him?
I did. I signed it and sent it back to Miss Brenda. He can pick it up downstairs in the clerk's office.
Thank you, Your Honor.
Thank you. Thank you, sir. Sorry about that. Usually I don't have much to do with that. So this is the first one I've signed in a few years. All right.
And Your Honor, while they're bringing up Mr. Cooper, Mr. Bledsoe, a matter from the 11 o'clock calendar, he's present in the courtroom. He just needs an explanation of the conditions of his sentence. He said that probation, he would have the opportunity to petition the court for termination of probation once his conditions were met.
Okay, he has to do that through probation.
That's what I instructed him, is that.
Sir, probation will bring that motion to me and they'll have me sign something. So
that was my question. I didn't know. So I was trying to.
Yeah. So if you want to if you complete all of your conditions, then, and you've shown proof to probation of all of the fines and fees being paid, any classes being taken, anything else that you had to do. So the DUIs were no problem. So I'll follow too close. I would definitely go ahead and if you've completed everything, then I would terminate or suspend. But your probation officer, once they verify everything's been done, they'll send me an order to sign.
And that I'm perfectly fine with. But this morning you said that wouldn't happen. So I was trying to get clarity on it.
It was.
I was talking about something else. Huh?
Your Honor, that was a misunderstanding on my part. It took me a moment to recall or to recover Mr. Bledsoe's sentence so I could understand exactly the circumstances for which his probation could end.
Yeah, because my understanding was you were here to change a no-low to a guilty, which I thought was strange, but
and that's correct, Your Honor. That was our original motion.
Yeah, so I'm fine with that. But if what you are saying is that you want the ability to end your probation because you've done everything, then that's handled through probation. If I said in the sentence that I would allow that, they'll send me a motion and I'll sign it when they verify everything has been done.
Yes, ma'am. And like we said, it was just the confusion in the wording that was used earlier.
That's fine.
Oh, we're good. Yes, ma'am.
Thank you, Your Honor.
Okay. Mhm.
Have a good day.
And we're waiting on Cooper.
Yes, Your Honor.
All right.
I will prepare the order and that will change it to the local deputy. Is he waiting for that? Yes.
Your Honor. I should mess up.
And Cooper's coming back up. That's what I'm in, correct? He's already did good. Just when she meets his.
No, I'm good. Too sticky. I got crowns and stuff. I don't know.
Are we ready on Cooper? Yeah, you're muted.
Yes, Your Honor. We're ready to proceed with Mr. Cooper.
All right. State ready?
No worries. That's good. He's off.
All right, Mr. Cooper, I can't see him.
They're bringing him out now, Your Honor.
Oh, okay.
Oh, can you ask, Mr. Cooper to come in? And if they just come up to, well, they don't, not up here, but just let them.
And is this non-negotiated or negotiated?
We're accepting the state's penalty offer, Your Honor, and Ms. Hegler, the one that you presented earlier today.
Okay.
All right, Mr. Cooper, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, so Mr. Cooper, you're before this court on 2024 CR 07029 for 2 counts of terroristic threats. Is there another case that we're proceeding on also?
No, Your Honor, this is before us.
All right, so but you're represented by the law firm of Blister, Holt and Dennis, and Mr. Taylor is with you at the podium. Mr. Taylor, what does your client plead to the offenses before the court?
2
counts of terroristic threats and acts.
Count 1, guilty. Count 2, guilty, Your Honor.
All right. By entering a plea of guilty to counts 1 and 2, sir, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, Mr. Cooper?
Yes, ma'am.
All right, factual basis and recommendation, please.
Yes, Your Honor. On or about June 2nd of 2023, Officer Romero did complete a probable cause affidavit. In that affidavit, the defendant was charged with 2 counts of terroristic threats. The defendant threatened to commit the crime to beat up his father, the victim Derrick Cooper, Derrick, and his grandfather, Leon Cooper. Specifically, the defendant stated that he will kick his grandfather's cancer ass, and he also said, "I would kick y'all ass." Your Honor, these events did occur in Clayton County. For count 1, the state is recommending 12 months probation, a fine of $300, 40 hours of community service, anger management, and to have no violent or harassing contact with the victim. For count 2, the state's offer is 12 months probation, 40 hours of community service. Again, no violent or harassing contact with the victims, and to run consecutive.
Okay, Mr. Taylor, is there any concern that I need to have?
A concern between Mr. Cooper and his father and grandfather? None whatsoever.
No concern about Mr. Cooper's mental health?
I don't believe so, Your Honor. I've spoken to Mr. Cooper and
Because
there's some outstanding charges, but there's some, as we said, we weren't litigating this case today.
Well, this is what I get, Mr. Taylor. I get that a family wants to save their son and they'll tell me anything about whether they took the threat seriously or whether the threats were made. Or, I take that with a grain of salt. It's the same as when somebody who's been in an abusive relationship comes to me and tells me that they want the abuser to come back home because, well, I mean, love will cover a multitude of sins. But Mr. Cooper, how old are you?
25.
Were you living in the home with Mr. Derek and Mr. Leon Cooper?
Yes, ma'am.
Why? You good and grown. You got your fancy earrings, your fancy haircut, paying money for all of those things, but you can't pay money for your own house. But you're gonna flip off at 2 grown men living in a house, 2 seniors, and you're gonna have a tantrum that results in you threatening to kick your daddy and your grandfather. I'm sorry. I was raised too old school to just take this in stride. First of all, we as parents are failing you children from this generation because y'all can't stand on your own 2 feet. Every time I turn around, somebody living with their mama and grandmama, the mamas and the grandmamas paying your rent, paying for your child support, paying for your place for you to live. I just really can't stomach it. And then when they do all of that for you, the way you repay them is you show your natural butt. I just don't understand it. It makes no sense to me. They're willing to, I bet the bond that you're on from the felony case, I bet one of them put their house up for it. If I'm wrong, I promise you I'm not. And in all of that, you have so little respect for what these gentlemen have experienced and have done and have gone through in life to put you in the to have the ability that you have, and you're gonna flow up in here with your little earrings and your little glasses and your little shirt, and you go because you're threatening old men. Where you get that from? Where they do that at, as the children say? This lack of respect in your generation, I bet there's a PlayStation or Xbox in their house. I bet they stay on while you use up their electricity. What job are you working at, Mr. Cooper?
I currently work at IHOP.
Oh, which if that's the kind of job that's the only job you can get, that's fine. It is a job. What happened with school? Did you finish high school?
Yes, I finished high school, ma'am.
Did you go to college?
No, I didn't go to college.
Okay. So they prepared the way. You finished high school. Did you get a trade? Did you get HVAC, plumbing, electricity, something where you could stand on your own 2 feet?
I've been working on trying to get trades and all that type of stuff. I've just been worried about my freedom in my life right now.
No, you shouldn't have been worried about your freedom, because if you were engaged in studying to get a trade, you wouldn't have had time to be in a place where you need to worry about your freedom. You'd have been worried about getting them grades or getting those skills. So you sitting around with too much time on your hands, and you ain't getting, you're not using it for a good purpose. You over there using it for a bad purpose, and then you're threatening the 2 people who stand in support of you. You're threatening the 2 people who stand in support of you. Now, while I understand the senior Mr. Cooper's father and grandfather for wanting to support you, they have done nothing to help you because you're irresponsible. You're disrespectful. and you're standing before this court after having threatened two people who are probably the only people remaining in your corner. You need to grow up, Mr. Cooper. But I tell you, as things go, you better hope several things. One, you better hope you don't get Judge Mason upstairs on your felony case, and you better hope you don't get convicted, because you'll grow up real fast in the Georgia State Penitentiary system. You will. They'll grow you up right and fast. All of the stuff that you had going for you, you don't have no better sense than to mess it up with foolishness. That's why I asked because if you had a mental health issue, then I could make some accommodation for that. That I would understand. But you just ruined. You just spoiled rotten and disrespectful. Let me tell you something, sir. No matter what happens with that felony case, don't come back before me with no misdemeanor. Please. Do not come back in this court. Please, please, and thank you. And what that means is you got 2 years, we in a relationship, 2 years to be on probation in front of me. 2 years. So for 2 years, you better toe the line. You come back for one probation revocation, we're going to have a whole different conversation. You understand me?
Yes, ma'am.
Because what you're not going to do is disrespect seniors on my timeline. You're not doing that. Especially the ones taking care of you, you spoiled butt. I'm going to accept your plea of guilty to count 1, 12 months probation, to pay a fine in the amount of $300, which will be $444, 40 hours of community service, an anger management class, and you're to have no violent or harassing contact with Mr. Derek Cooper or Mr. Leon Cooper. And I'm telling you, I really wish it was no contact. I'm honoring their wishes, not yours, because I know over the course of the next several years, you're going to need them. But really, it should be no contact, because you should be forced to stand on your own 2 feet. What count 2 will run consecutive, which means that it will start when the first one ends, and then you will have another 12 months probation, 40 hours of community service, and no violent or harassing contact with Mr. Leon or Mr. Derek Cooper. We clear?
Yes.
Have I made myself clear, Mr. Cooper, about how I feel about this?
Yes, ma'am.
Have I made myself clear that you need to grow up?
Yes, ma'am.
You have children, Mr. Cooper?
No, ma'am.
Please don't have any children, Mr. Cooper. Not until you become a mature adult. Because age ain't nothing but a number when you act like a kid throwing tantrums. All right, sir, you're going to leave the courtroom. Yes, sir?
Your Honor,
I'm not waiving fees, Mr. Taylor.
I'm not asking that. I just, Mr. Derek Cooper is the named victim, wished to make a statement.
Sure, I'll talk to Mr. Cooper. I got a piece I want to say to Mr. Cooper. Come on up, sir.
And I would point out that Mr. Cooper, Derek Cooper, reached out to me directly. I didn't go to him and ask him what he was going to say to the court. And he also reached out and wrote a statement to the solicitor's office prior to this case coming to court. So I just wanted to say this, Mr. Derek Cooper's actions were initiated of his own volition and not by any request or coercion from the defense.
I didn't take it as such, Mr. Taylor, but thank you for clarifying the record. Move Mr. Nazir out of the way. And let me hear from Mr. Derek Cooper.
Good afternoon, Your Honor.
Good afternoon, Mr. Cooper. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true?
Yes, I do.
All right. All right, tell me what you got to say, sir.
Yes, Your Honor. I just wanted to say, during that time, I was going through cancer surgery. I was under a lot of medication, a lot of stress at that time. I believe the situation was not necessary. It was overblown. And I was taking about 7 different medications at that time. And I would like for this to end, which, I think you ended today. But I just wanted to say it was blown out of proportion. And I should have used better judgment, but I was incoherent at that time. I was under.
Well, Mr. Cooper,
I'm not on it no anymore, but yes, ma'am. Yes, ma'am.
Excuse me.
All right, so Mr. Cooper, I hear all of that. And while I wish you well with your cancer journey, none of that erases the fact that your child is spoiled. He's 25 years old, sir, and we're ruining a whole generation. When did you, when you were young, when did you leave your parents' home never to return?
At the age of 19, I joined the United States military.
Okay. What I say to you is, and I say this to a lot of parents, what my mama, my husband's mama and daddy, what a lot of people who are successful, what their parents have said to them is, okay, you finished high school, you don't have to go to the military, you don't have to go to college, you don't have to go get a job, but you got to do one of those three. I'm not forcing you, I'm not choosing which of those paths you take, but you can't live here. Because I'm grown, you need to get grown. You are you've reached the age of majority, you're legally grown, but now you need to take on some responsibility that makes you grown. What you've allowed your son to do is sit up in your house, use your electricity, dress and spend his money on what he wants to spend his money on, take no responsibility for anything else, not even for himself. And then he's become so spoiled that even in the midst of your cancer journey, he can't find compassion enough to watch his mouth in your house that you pay for. He paying any bills?
He gives me money.
But he living up on you. See, so Mr. Cooper, while I get that all of this is, you feel like you were taking medicine and you were going through your cancer journey. I get that. And like I say, I pray your strength and health. But we have got to stop turning out little boys and start raising men. We are allowing them to just be irresponsible. And then those same irresponsible people go out and then produce more kids that they're not being responsible for. Thank goodness he hasn't had the wherewithal to go out and have a child and be irresponsible. But that boy irresponsible. He is spoiled. And I promise you, I don't need you to verify it for me, but I promise you, the only reason he is out on bond on that felony is because you probably put up your house, you or your father. And sir, you have been in the military. You know that's not how men are made. You don't make a man coddling them. You know that. But that's what you're doing. Every person who is going to become a responsible adult has to walk their own path. And I say that from the standpoint of somebody who has gone to school and worked 2 jobs at the same time while I was going to school. Gone to school and worked full time, or gone to school and worked several part-time jobs to make it happen. Not that I didn't have the support of my family, I did. But if I was going to get out there and achieve, I had to make it happen. All you're doing is supporting him and being trifling. Because if he doesn't ever get out and face challenges, he will never grow up. He will never learn if he's responsible. He will never learn to meet challenges. He will never learn to stand up on his own 2 feet and be a man. And when you leave this earth, what you will leave is somebody who can't take care of themselves, no matter how much money you leave them, no matter what kind of house you leave them. I have heard stories of kids who have been given insurance money, a house, and a car when their parents leave this earth. And within a year, they broke and homeless because they're irresponsible. Give Mr. Cooper, young Mr. Cooper, a deadline to get out of your house, a firm deadline. And make him be out on his own. If he got to have 10 roommates and he paying 1/10 of the rent portion, if that's what he needs to do to be a man, make him do it. Because I promise you, the path that he is on is because he's spoiled and doesn't have any responsibility. people who got responsibility, they don't have time to be threatening folk. They working too many jobs. They're trying to figure out how to get to the next level so that they don't have to work so many jobs. They're trying to figure out how to buy a house or rent a nice apartment or have a car, focused on that, as opposed to I can sit up on my parents, use their electricity, play PlayStation or Xbox, Madden all day, rack up my points on my games because you got to play the dailies. I know all these things. And then disrespect the people who are trying to help me. And so I say to you, sir, I know you want to help him, but you're not helping him by coddling him. And you know deep in your heart, you didn't get to be the man that you are. Your daddy didn't coddle you, did he?
No, ma'am.
All right, then. So release him to be the man that he needs to be.
Yes.
Kick him out your house. Give him a deadline. All right?
Yes, ma'am.
And I appreciate your support of him. We all need it, but you don't have to carry him on your back. He got to learn to walk. All right. Thank you so much. All right, Mr. Cooper, young Mr. Cooper, remember that you and I are in a relationship for the next 24 months. Every time you mess up, you will come back and see me. And I have up to 24 months that I could sentence you to. So please be mindful of that. All right, thank you, Mr. Taylor. Anything else we need to talk about before we conclude the criminal calendar? I think this was the last one.
Does Mr. Cooper go into custody based on the bond revocation and get?
Mr. Cooper's bond was revoked, but because we have resolved the case for which the bond was revoked, I will allow Mr. Cooper to change. That will be changed to Mr. Cooper being on probation for the sentence. So that bond revocation now will become the sentence of probation that he has received.
So he needs to meet with the probation officer now.
Mm-hmm. And then go ahead and write the order clarifying that for me, Mr. Well, it shouldn't matter. I think it should switch over.
I believe
Yeah,
so.
he doesn't have to be taken into custody at this time. But if the deputies need something to clarify that, just write it up and I'll sign it.
Okay. Thank you, Your Honor.
All right. Thank you all. Much more efficient handling.
What about parts, Judge? The
Your
state is
Honor.
ready on parts.
Oh, that's right. Parts was the last one.
So,
Much better today. Thank y'all so much. On Dion Ector Parks. Let's see. Mr. Parks is ready for a plea. What's going on? Or a hearing?
He's not ready for a plea. Just to kind of state the position, I believe on jury trial date, Your Honor appointed Lister Holt in court to represent Mr. Parks. At that point, we had not submitted an appointment order, and I suppose that's my fault. I know I got sick afterwards, but I know no appointment order has been submitted, so I can't say I'm ready, but I'm here, and so if
Okay, what's the motion to revoke bond based on a subsequent charge?
Yes, that occurred this year, 2024. So the state is ready.
Okay, how hard is that, Mr. Lynch? I appointed you. I remember that one.
I understand. I don't have any information, and I understand what you're saying. How hard is it? And I would just point out, Mr. Parks is held on other issues. I don't have any information about his bond, but if we're going forward, I will be here to represent him as best I can with what I have, which is.
All right, well, let's go forward because this is whether he got another arrest or not. So, yes.
No.
I mean, I could see if it was based on the substance of whether he made contact with somebody or committed some other, or there was other conduct, but this is based on whether he was arrested or not in violation of the bond conditions.
I would just respectfully, I understand what the court's saying. I would disagree. I would argue that it is about whether he violated his bond conditions by committing a new offense. Because we all know we are innocent until proven guilty, and the fact that someone's arrested for something does not mean that they actually did the offense. And
so we should just hold all the bond revocations until they've been convicted.
No, Judge, but I would argue that the state has the burden to present evidence that the offense actually occurred, not just that the arrest took place.
Okay, and I assume that's what the point that Mr. Taylor was making with his case with Mr. When he initially stated that with Mr. Cooper. But the difference between those is that what Mr. Taylor was saying is that the individuals did not want to pursue the charges. That is different than whether the person actually committed the offenses, whether he actually said the words or issued a threat. And so my ruling at that point was correct, and I think I'm ruling correctly this time. Let's go forward with the hearing.
Okay, we need Mr. Parks.
And 1 second, Your Honor, it appears that Sergeant Williams logged off, so trying to get her, so I can back in now. So, and then we can get started.
Okay.
Thank you, Judge, for your patience.
They do.
All right, Mr. Ector, raise your right hand for me. Do you solemnly swear, I'm sorry, Mr. Parks, do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right. So you're represented by the law firm of Lister, Holt, and Dennis. Mr. Owen Lynch is representing you in this case. The state has brought a motion to revoke bond based on the fact that you were on bond with one case, and it is alleged that you committed a subsequent offense, even though you were on bond with the order to not commit any other offenses. And at this time, the state is ready to go forward. Ms. Jameen Hagler is the Assistant Solicitor General who is prosecuting the case for the state. Ms. Hagler, you may begin at this time.
Thank you, Your Honor. My officer is still logging in, so it's requesting a few more minutes for her to get signed back in. Thank you.
What's a PTD form?
I did, and I gave it to for Ms. Groom. It's in her office, and I've got a stamp copy there.
So submit it to Solicitor's Office.
I've already submitted it.
Okay.
Should be at the front desk if it's not back yet. So,
Sergeant Williams
Can you hear
present.
me? Oh, I'm sorry. Can you hear me, Sergeant Williams?
Yes, ma'am.
Okay, limit the judge on that on and we'll go ahead and get started. Thank you. Judge, we are ready to proceed whenever you are.
All right, the state is ready to proceed. Go ahead. On the Parks case, this is case 2023 CR 07171. Mr. Parks is charged on this case with driving on a suspended or revoked license, no insurance, and defective equipment.
Yes, Your Honor. And before I swear Sergeant Williams in, just asking the court to take judicial notice that the defendant actually received a signature bond on March 9th of 2023 on the case that's currently on the calendar. And so we would just argue that the general conditions of bond would apply pursuant to OCGA section 17-6-1 to include not committing any new offenses for judicial notice. Thank you, Your Honor.
I would object to the court taking judicial notice. I would argue that the conditions of bond that he's alleged to have been violated need to be presented to this court. And I haven't seen them, so I think
he has a signature bond.
Signature bond would have been one of the magistrate court doesn't give them, is my understanding.
Right, and so, but I would argue the state needs to present evidence of specific conditions that he was given notice of, and that hasn't happened. So,
a copy of the bond.
I do not, Your Honor. When I tried to get a copy, I was told they had a signature bond. There wasn't any documentation in the system that we could get.
Well, if there's a signature bond, it is one I signed. So that will be documentation because I would have had to sign it. I don't know that magistrate court gives signature bonds. Do they do that now?
I was told that he received a signature bond. We called down to the sheriff's office. That's what we were told for the traffic offenses. That's what we were told.
Well, the clerk's office would have any bond that I signed. Otherwise, the clerk's office should have a bond that he would have gotten at first appearance. Even if it's a signature bond, it would have had been signed.
The only thing that I found in the system was the appearance bond, and it was still dated for the same date, March 9th of 2023. So I do have copies of an appearance bond, but I did not see any additional, I did not see anything aside from that. And I was told that he was given a signature bond for the traffic offenses, again, on March 9th of 2023. So we do have appearance bonds that I do have copies of that was signed, but that was attested by Kay Anderson, and it was approved by A. Parks.
Yeah, I don't know what that is. If it was one of my bonds that I signed, if they missed court on a bench warrant, then fine. I know what that bond says, but I don't know what this says. And I would need to know what this signature bond says.
Yeah, sure, and I understand. Unfortunately, like I say, we weren't able to get a copy and was told that there was nothing in the system at the time for the signature bond.
Motion is denied. I mean, the motion is denied. Mr. Parks is being held on other charges. Unless y'all are ready to go forward with a plea, then we're going to adjourn.
thank you, Your Honor.
All right, thank you.
Thank you, Judge.
All right, thank you all. Take care.